Appellate side mentioning.
Well,
Wait. Yes.
I was praying for your lordship's leave to mention an application which was appearing last Monday as item 151. It is due to appear next Monday again.
Yes.
Well, I was only making a request on behalf of Mr. Chidambaram. Well, the matter concerns wrongful debiting of interest by a bank. Well, we want have taken out an application for referring the matter to an independent auditor for that purpose. He was only making a request to your lordship if your lordship can take up the matter on Monday at any fixed time.
This is a matter where Mr. Chidambaram has already made his submissions or some other matter.
No, this is a matter in which Mr. Chidambaram had earlier made submissions before another bench, not before your lordship.
Very well. Key matter. What matter is this?
Well,
I remember another matter where Mr. Chidambaram has already made his submissions.
the mentioning memo and
the Enforcement Directorate is making now.
Well, this is not the same matter. Well, this is another matter for wrongful debiting of interest by the bank, contrary to the agreement. But the application
But
should
this is now before my court.
Yes, madam.
I don't remember this matter. And why is it now before my court? It's a new matter.
No, your lordship now has the determination. Well, initially the Reserve Bank was directed to appoint an auditor.
Very well, Monday. Notice to the other side, please. Is it due to appear on Monday?
Yes, madam. It's due to appear on Monday.
Very well. Yes. Microphone, please.
Item number 141 of the listed motion. It is relating to the senior citizen.
Can't hear you. Microphone, please.
It is this writ petition is under the provisions of the welfare of the senior citizen.
Yes.
One son out of one son grabbed the entire property.
What is the date of the order?
Date of the order, my lord. Government directed the distinguished state to pass the order, but I distinguished state last 1 year he is not passing any order. We have filed writ petition, still he did not move, pass no order.
Very well. When did you file the writ petition?
Yes, my lord. September 2022.
Very well. It will appear in the first week of May. Yes.
May I have your lordships kindly to mention a matter. 122 of the list today. The urgency 122 of the list today. The partnership has a bank account with Indian Overseas Bank. It's a real estate firm. Milord, on the complaint of a disgruntled partner, 1 out of 4, the bank has frozen, Milord, all debit fees. Milord, the entire
when?
13th March
What
was
is this? Yes.
the 13th March was the freezing. After that, correspondence was exchanged up to 20th March, and we filed the writ petition on the 29th of March. Milord, it's a real estate project. Milord, the entire operations have come to a standstill. I was only praying, Milord, for
24th.
Kind leave to mention a matter, my lord. This matter I had moved in the original side, but one of the respondents was, my lord, not having office within the original side jurisdiction.
Yes, I remember.
My lord, thereafter, my lord, after lordship's order of 29th March, 30th March, we receive a notice from the authority saying that a hearing would be conducted on 10th of April. My lord, 10th of April, we attended and we sought for 15 days time because the writ petition is pending. My lord, I was only praying, my lord, we have taken steps. It's now converted and given an appellate side number. I was only praying, my lord, if it can appear any day, my lord, next week, my lord, subject to the convenience of the
20th.
I'm grateful, my lord.
Lord, may I please to mention one urgent matter. My lord, on 4th of April, my lord, there is a notification by the the Register General of Marriage, my lord, by which, my lord, the jurisdiction of the marriage or non-official marriage officer has been cut down, my lord, from 4 police stations to 1 police station. And my lord, the notification is going to be effective from 17th of this March. Like, file the
date of the notification is when?
4th of April.
Of this year?
Yes.
And effective from?
17th of April.
17th?
Yes.
Very well. On 24th? Yes.
Well, maybe some privilege.
To the other side. Yes. Very well. 18th. 18th.
Your lordship, this matter is appearing at serial number 146. I had mentioned it earlier too. The applicant has been denied the inspection of the answer scripts, and the certified copies which are provided lacks the counterpart, which is blank. There are serious discrepancies and order.
Who is the relief sought for against? Who is the relief?
Service Commission, West Bengal Service Commission. Your lordship.
West Bengal Service Commission.
Public Service Commission. Yes, your lordship.
Isn't there a bench dealing with these matters?
Yes, this matter
there is a bench dealing with these matters.
Your lordship, this matter is listed under your lordship.
I will release it. Yes, sir. To be mentioned, Rapporteur number. Yes.
My lord, may I be permitted?
There is a bench dealing with these kinds of matters. Please find out. Yes.
My lord, may I be permitted to mention one matter before your lordship? My lord, this matter is relating to a tender which was floated by the Indian Oil Corporation Limited for carrying petroleum products. I am one of the applicants herein, and a private respondent have been selected by uploading fake and manufactured registration certificates of tank trucks. Now, the last date of impugned action was 7th April 23, my lord.
I can't understand a single word you're saying. What is the last
Last-
cause of action?
The last date of impugned action was on 7th April 2023. The technical result was been published, and the urgency is that the work order is going to be issued on 21st, my lord.
I will not take it up before the last week, 28th at best. Yes,
But,
notice to the other side.
I
Yes.
have my lord's kind leave to mention a matter of item number 331 of your monthly lordship's monthly list. My lord, thrice it has been mentioned, your lordship was pleased to upgrade, but due to paucity of time, it could not be taken up and matter went down. My lord, I am seeking leave to renew my prayer, my lord, if the matter be taken up any day convenient to your lordship. My lord, the urgency is that, my lord, the death benefit which is applicable to the petitioner niece, but that has been denied only on the ground that why the mother has not been made a nominee. The niece is a nominee. The uncle died as per the proposal of the Life Insurance Corporation, Life Insurance
Yes, 28th.
20.
Yes.
Grateful.
Petitioners are fly ash brick manufacturers. They used to get their raw material from the respondents. There was an agreement. It was time to time extended till 2021. At the year of 2022, the respondents are allocating their unused fly ash to some others, and they are not extending the agreement.
Cause of
On
action.
June 2022, I have made a representation for extension of the agreement, but they have not responding to.
June 2022,
Yes.
not before the second week of May.
Lordship, I have filed this matter on 2022, Lordship.
Yes, second week of May.
May I
Yes.
be permitted, my lord, I had mentioned this matter before your lordship, my lord, on 30th March 2023, my lord. My lord was pleased to direct that the matter be appeared on 11th April, my lord, but the same did not occur, my lord. But what has happened in this matter, my lord, the petitioner is involved in the business of fish farming, my lord. He was
What farming?
fish
Yeah.
farming, my lord. But he was blacklisted for 5 years for not participating in the tender, my lord, without giving any opportunity of hearing or so cause. My lord,
What is the last cause of action?
last cause of action was, my lord, 20th March. I have filed this writ petition on 24th March 2023. I had mentioned this matter on 30th March. My lord was directed to please.
Yes, 28th, notice to the other side. Yes.
28th, obliged, ma'am.
My lord, may I be permitted to mention, petitioner here applied a
Move the
passport.
microphone so that I can also see you. Yes.
My lord, the petitioner applied a passport by depositing requisite fees and for correction of the date of birth. Verification has been conducted till date. No passport has been issued in favor of petitioner, my lord.
You don't have any dates.
No, my lord.
Don't have any dates. Come back and mention again.
No,
Yes.
my lord, the inclusion of the list, my lord, there is no.
I need some dates. Otherwise, I don't allow mentioning. Yes.
My lord, may I permit to mention upgradation, my lord? We have, my lord, petitioner's father deposited with joint account with my petitioner. My some part of the amount has been paid to my petitioner, but another part has not been paid.
What is all this? Who is the respondent?
State,
Come back with
Back.
facts. Yes.
The private respondent has prepared fake deeds, practicing fraud upon the petitioner. The petitioner informed the registering authority for cancellation of the fake deed. But as per order of
How are you concerned about the private respondent's fake deed? What is the relationship?
I am for the private respondent, no relation, They are
You are suffering an order?
yes,
Since when? So say that to the court.
yes, as per the order of the government, if any information
Come back with dates. Yes.
Malad,
Come back with dates.
Of-
Yes.
This is a matter, my lord, where I'm a restaurant owner. I have applied for a license. I was
What do you mean by a restored owner?
a restaurant.
Yes. Restaurant. Yes, say that. Yes.
Sorry. Now, this restaurant, I've applied for a regular license before the district magistrate in November 2022. Since then, the restaurant is closed. There are 32 employees in the restaurant, and I'm not being
So you're
able.
closed since 2022. Why are you mentioning in 23?
No, my lord, we have mentioned it several times, my lord. We have
When
filed
did
it
you file the writ petition?
in January 2023, my lord.
Then you have survived
My lord,
for 1 year.
no, in January 2023, we have filed the writ
Come
petition,
back
my
with facts. Yes.
My lord, I have took loan by depositing my title deed in original, my lord. My lord, now I have paid all the loans amount, my lord. This is the receipt, my lord. And I have paid for the return back for the original deed, my lord, that has not been considered, my lord.
Dates,
This, my lord, February 2022.
come back with facts,
May I
dates,
permit to
yes.
mention one
No, come back with dates,
one
don't
non-
waste time. Yes.
non-prosecution, your lordship.
Which year?
2023, I have filed this writ petition on 2023.
Yes,
and,
19th.
nine-
Yes.
I'm praying for upgradation of item number 152 of today's list, my lord. It's a matter regards to a child who is living in home. He has lost his father, my lord, and the family members are not allowed to have access to the child for the last 1 year, my lord.
Last 1 year?
Yes, my
When
lord.
did you
About
file the
1
writ
year.
petition?
My lord, December 2022.
Who are you? Who's the
I am the
petitioner?
aunt.
Aunt.
We used to have access to the child over telephone. We used to visit them.
Give me some dates. You know the rules of this court. What are the dates? Why should I include the matter?
My lord, it is already included. I am up for
Very good.
upgradation.
Come back
my lord, I
with
am-
facts. Yes, I don't upgrade
for-
matters. Give me dates, then I will. Yes.
My lord,
My lord, it is the date claim. My mother died on 28th June 2020. The LIC has already only released the premium amount. The maturity value they are not releasing despite repeated representation. I am from 2022. I have filed the writ petition, but it has not yet come. I am unable to pay the loans I have taken for
Very well.
treatment
Second
of
week
my
of May. Yes.
May I be permitted to mention for
No, not you. Yes, you.
may I be permitted to mention for inclusion, my lord, the petitioner is an electrical contractor. His contract has been terminated, my lord. If it can be included in the list, my lord.
No dates. Come back.
My
yes.
lord, it is.
No, come back. Come back.
February, my lord.
Come back.
But
come back.
my
Yes,
lord,
yes.
my lord, kindly bear with me
No,
for a
no,
moment, my lord.
Come back. Yes.
May I be permitted to mention one matter for inclusion being contempt application number 119 of 2023 arising out of WPA number 18228 of 2022, wherein your lordship by an order dated.
What is all this? You don't even know the date of the order and you're mentioning all giving.
Your lordship, I know the order. I know the order.
What is the date?
The date is 18/11/2022, wherein your lordship directed the respondent
Come back
authorities.
in May and mention. Yes.
Your lordship, kindly please. Your lordship, I am appealing for the third time.
Yes.
The first time,
Yes. Yes.
My lord, under extreme urgent, my lord, circumstance, petitioner, my lord, appeared in the for the post of state legal services, district legal services chief. For North 24 Parganas, he stood first in the panel. Without cancelling that panel, second appointment process has been initiated and that interview date is fixed on 17th. He is also participant. My lord, I am praying for 17th is next Monday. My lord,
When did you file the writ petition?
my lord, I filed on 31st March.
When did you get to know that he has been unsuccessful?
My lord, till date, he has not been informed that earlier
Not
notification has
before the
been
last
cancelled.
week of April. Yes, 28th.
My lord,
Yes.
I'm grateful. My lord, I have paid the amount, my lord, on 4th January 2022, my lord, and I have filed representation,
No,
my
you.
lord,
I've asked you to come back. Yes. Any new mentionings? Yes.
Lordship.
Permitted to mention a matter for upgradation of.
Can't hear you. Yes.
May I have your lordship's kind
Yes.
leave, my lord?
Yes.
This
No,
matter
only first mentionings. No second mentionings. Yes.
this matter, my lord, it appeared, my lord, this matter appeared, it warmed up, my lord, there was argument also. On the 18th, it was directed in August 22 to appear. It appeared, my lord, from listed category, it went into monthly list, my lord. This matter has come up, my learned senior friend, Mr. Bhattacharya, had to leave for parliament. And on that ground, my lord,
Yes, first week of May.
I'm
Yes.
briefly obliged.
Lordship, 29th April, the matter has been filed and it is not appearing. The urgency is the joint video.
29th April.
29th March, Lordship. 29th March, it has been filed for listing. It is not appearing, Lordship. The joint video quarter of Fulia is enjoyed by private respondents. And that is the urgency, Lordship. You have made a
Yes,
representation.
28th April. Yes.
My lord, may I be permitted to mention a matter? It is a matter for non-prosecution withdrawal. The matter.
Which year?
2021.
Yes, 17th by 18th the other. Yes.
Permitted to mention a matter for upgradation, lordship.
I can't hear you. Yes. Anybody else? Yes.
My lord, may I please take your lordship's leave to refer a contempt petition, my lord, file it on the basis of notarized affidavits, because my lord, the petitioner has a 5-year-old daughter, and the petitioner, my lord, lives in Darjeeling.
Don't know the date of the order.
My lord, the date of the order of contempt is, my lord, August 11th, 2022. But the act of contempt has been committed on the 20th of January. Since then, we've been writing to them that you please don't do this against us, but there has been no response.
Don't make all these vague submissions. What do you mean? Please don't do this against us.
No, my
How
lord,
will the court know what you're saying?
I'm so sorry, my lord. The difficulty is that your lordship had directed, my lord, not to give any further effect to certain allegations leveled against me in my employment. Now, my lord, despite that order, my lord, effect is being given to the extent that I'm not being considered for promotion on the
Yes,
basis of the same allegations.
4th May. Yes.
Lordship, may I please? I am the petitioner, your lordship. I have constructed a railway side writ against the railway authorities, your lordship. under the Gati Shakti policy of 2021, I am entitled to receive certain reimbursement. The amount has become due in 20th
course of
on
action.
20th February 2023. I have filed my writ on 31st March 2023, Your Lordship.
Yes, first week of May. Yes.
Lordship, may I permitted to mention a matter for upgradation, which is listed as 190 item 191 of this monthly list. The matter is on 17th of May 2022, the registry department has registered 5 deeds of the petitioner, but till date no deed number, even the deed number has
When
been
did you
provided.
file the writ petition?
Lordship,
Yes.
I'm
Come back. Yes.
Or may be permitted to mention, madam.
Come back with facts.
July.
Come back with facts.
Petitioner was engaged under the State Bank of India as a customer service provider. His service has been terminated on 24th of March. I have taken out the writ petition on 3rd of April, madam.
Don't know the year.
Yes, madam, 2023.
Yes, 3rd May. Yes.
My lord, may I be permitted to mention a new motion, my lord? The matter was the matter was released from court number 10 at 31st August 2022. My lord, the matter is in relation to my
Yes,
lord,
come back in the last week of April and
Lordship, may I be allowed to mention one matter, 3 matters for upgradation, which is running in the daily list of today. Item number
connected
18 and-
matters.
Huh?
Connected matters.
Lordship, they are similar matters. I am the finance company. My section 14 application is pending since April 2022. I have followed them for several times. I have sent them a letter.
Yes, 2nd May. Yes.
May be permitted to mention, my lord, this is matter relates to section 14 of the Surface Act, my lord. The learned district magistrate has not passed any order, my lord.
Application pending since?
My lord, last
Come
last
back
year.
with facts. Yes.
My lord, I have filed a writ petition in December 2022 challenging the order of the collector, my lord, where the stamp duty of an immovable property was fixed, my lord. Now, this assessment was done pursuant to impounding of the instrument in an arbitration proceeding, which is pending. My lord,
Dates?
my lord, arbitration proceeding is pending. Assessment order was passed on 25th of August 2022. I filed the writ petition in December 2022.
Yes, mention in the last week of April. Yes.
May I have your lordship please to mention a matter for inclusion in the list, my lord.
Microphone, please.
Yes, my lord, but it is not included.
Microphone, please.
May I permitted to mention one matter for inclusion in the list, my lord? Deputy Tika Controller passed a memo without hearing to the petitioner. Now the petitioner
What is passed a memo? What is the effect of that?
A memo is passed for disposes, sees the Tika tenancy of the petitioner, my lord. Now I have anticipated, I am dispossessed, and they took initiative since December 2022.
Come back with dates. Yes.
May I have your lordship, we have to mention a matter, your lordship. The interim order passed in the above matter is expiring on 30th of April. The matter is running in the list as item number 115, your lordship.
Yes, on 28th to be mentioned. Notice with the other side, please. Yes.
With my all humbleness, may I mention item number 139 for upgradation. My urgency is I am suffering with a debarment order, life banning, which is my only livelihood.
When did you file the writ petition?
But I filed the writ petition immediately after I am faced with the debarment order in the month of August 2022. The affidavits are complete. My urgency is only is the month of in the end of April, May. They are floating a years-wise tender process. And they are without any subjective.
4th May. Yes.
I'm deeply grateful.
Lordship, may I be permitted to mention one matter for upgradation? The urgency is that in a section 14 application by the bank, the orders were passed for taking physical possession. Thereafter, on an application by an alleged tenant, the learned CMM has passed certain orders in spite of him being functions officio. Lordship, the last order was
You're the borrower.
I'm the bank, Lordship. In my application under section 14, after I have been directed to take possession, one application was moved by one alleged tenant, and in spite of being functors officio at the then point of time, the learned CMM,
Dates.
Lordship, the last order was passed on 17/8/2022. I had filed the writ petition on 23rd of September 2022. Lordship, the difficulty is being that there are several essay petitions also pending before the Debts Recovery Tribunal. Now they are showing these orders and trying to prejudice the.
Yes, 4th May.
I'm grateful, Lord.
Yes.
The writ petition was filed challenging a tender process. Lord, your lordship, Lord, at the interim stage, directed ECL to Lord make a survey of the entire project. Lord, then the matter is appearing in the monthly list. Lord, they
Hurry up, Mr. Chakraborty. What is the urgency?
Proceeding with the tender process, my lord, if it may be
What
taken up.
they are proceeding, I have very vague submissions.
Lord,
What
I
they are proceeding.
challenge the tender, my lord, on the issue that they have not, my lord, measured the project, the quantity that I performed. Your lordship directed.
Who is they?
Not the ECL. Your lordship directed the ECL to, my lord, measure the quantity that I performed, but the measurement is not complete till date. Not already 2-3 months have gone, and my lord,
Second week of May. Yes.
May I permitted to mention one matter, Lordship. Lordship, I am coming for upgradation, Lordship. Today list it is appearing item number 110, Lordship. Urgencies, Lordship, for RTI reply, Lordship. Lordship, one matter has been pending in Honorable Justice, Lordship, Vishwajit Basu, Lordship. The RTI is necessary for this matter, Lordship. Kindly, Lordship.
Justice Basu's matter, why should I take it up?
Lordship, no, Lordship, RTI matter is,
They are like with facts, I can't understand. Yes.
May I, Your Lordship, be permitted to mention? Your Lordship, this writ petition is this is for inclusion in the list. The petitioner is seeking to be appointed as a legal guardian of his wife, who is a mentally disabled person. Now,
who is the petitioner?
Petitioner is the husband of the person who is mentally disabled.
So what appointment as legal guardian? Already the husband.
No, Your Lordship, we have to the person for whom the legal guardian has to be appointed is going through dementia. Dementia, Your Lordship, has not been recognized as a disability under either Mental Health Care Act, National Trust Act.
What is the urgency?
Urgency is, Your Lordship, the wife is 75 years old and their doctor's prescription to show.
And how old is the husband?
Husband is 83.
83. And he wants to be appointed as legal guardian.
Yes, Your Lordship. He is physically fit, Your Lordship, but the wife is extremely in the very vegetative state. Therefore, immediate legal.
What is the last cause of action?
Last cause of action is, Your Lordship, 29th August of 2018, when the guidelines came and declared.
And they don't have children.
They have children, but they are all outside. Both of them are in USA.
Yes. On 24th.
Grateful, Your Lordship.
Any other appellate side mentioning?
May I be permitted to mention?
Yes.
My lord, may I be permitted to mention, my lord, it is item number 154 of today's list, my lord, listed motion. My lord, the urgency is that my live consignment of tea, which was imported.
I can't understand what you're saying.
My lord, the live consignment of tea imported on.
What is live consignment of tea?
My lord, it is a reimportation of tea, exported and returned. My lord, your lordship has already taken up this matter on earlier occasion. My lord, it is running in the list in item number 154.
Come back with facts. Yes. I can't understand the urgency.
Mention, my lord, one matter, my lord, which is running as item number 650 of the monthly list. My lord, 4 lakhs of my lord stamp duty paid. After that, my lord, the deed not registered, my lord.
Come back on the next day. Yes.
For accreditation, my lord, item number 168 of the monthly list, your lordship. I am aggrieved by non-disposal of my section 14 application pending since 2018. I also filed a writ petition where Honorable Justice Devanshu Bajaj, by order dated 15/11/2019, directed the district magistrate to dispose of the application within a stipulated period. Several communications made. In fact,
you should have filed a contempt. You filed a fresh new writ petition.
Your lordship, since
not before the second week of May. Yes.
My lord, kindly allow my mentioning, my lord, because petitioner is old lady. She applied.
Come back on Monday. Yes.
Yes. This matter is related to the additional public prosecutor who are working in the Baripur subdivisional court. And your lordship.
Come back on Thursday. Yes, Monday. Yes, original side mentioning.
May I have your lordship indulgence to
Original
mention
side?
Original side matter.
Yes.
Original side mentioning.
There's a direction where the matter will appear on 17th. My bank account has already been seized, and thereafter, the Director of Revenue Intelligence, they have used affidavit. They have defreezed the account. In spite of that, bank is not allowing me to afford at my bank account.
What is the last cause of action?
Last cause of action, that is in the year of 2016. But since then, it was stopped. My bank account.
This will not be taken up this side of the vacation. Second week of May. Any other original side mentioning?
My lord, since 24th December 2022, my lord, my musical shop instrument
I
has
can't
been
understand.
locked.
Move the microphone. I
My lord, my
can't see you also.
musical instrument shop has been locked by the official trustee without any order or without any order of the court.
When? When was
From
it done?
24th December 2022.
When you
Thereafter,
filed
on
the
5th
petition?
January 2023, I filed a writ petition. Thereafter, affidavits direction pass, affidavits complete. My lord, the matter is appearing as item number 21 in your lordship list. My lord, on a regular basis, I am
First week of
actually
May. Call on the list, please.
on a regular basis, my lord, I am suffering a loss of
Call on the
30,000.
list.
For orders, item number 1.
First week of May, koro daw eta matter last day.
My lord, I know your lordship is pronouncing the order, my lord, in item.
I have already dictated the order.
Only 3 facts, my lord. I would like.
Mr. Mitra, no, I have dictated the order.
These were not within my knowledge.
No. The facts taken together with a balance of convenience would demand that the clock not be turned back to the pre-auction time. The auction for the assignment of debt was held in January 2023 and the highest bidder declared on 24th January 2023. The bank has also received payment of rupees 17.59 crores consequent upon the auction. The bank is entitled to an assignment of its stressed loan debt to an ARC under Section 5 of the SARFAC Act. The petitioner's repeated failure to stick to the payment schedule, as seen in the 5 compromise settlements from 2015 onwards, does not inspire any confidence in the petitioner's payment capabilities. The petitioners have nothing to show in terms of honoring the payment schedule in the last compromise settlement of 10/1/2022. The Supreme Court in State Bank versus Arvindra held that a borrower who has not made payment as per the sanctioned one-time settlement scheme cannot claim any extension of the scheme as a matter of right. Last but not the least, the petitioners have not been able to show any particular prejudice resulting from the assignment of the stressed loan exposure to the ARC under any statute or otherwise. The ARC has not been made a party to the writ petition, and the court hence did not have the benefit of hearing the assignee, auction purchaser of the debt. The court is disinclined to grant any relief in favor of the petitioners for the above reasons. Although affidavits have not been called for, counsel appearing for the parties have made detailed submissions in support of their respective cases. WPA 4711/2023 is accordingly dismissed without any order as to cause for want of merit or any ground made out for interference.
Lordship.
Miller, the can is also, they have filed a can yesterday.
Who has filed a can?
Miller, they asking for addition of party of the new person.
Very well. देखिए can टा दाओ तो.
In view of this order, they can stand.
Can 1 of 2023.
What is just give me the pair in the can, please.
Can a paper to the
Number can number 1.
can 1. It is appearing in the list. Is it appearing?
List আছে তাহলে এখানে কেন নেই? It's not yes, can 1 of 2023. কালকে file
They
করেছে।
served yesterday and
The petitioners have filed an application, can 1 of 2023, on what is the date? There's no date.
yesterday.
Yesterday, i.e. Twelfth April 2023 for addition of the of CFM Asset Reconstruction Private Limited, which is the asset reconstruction company who has been assigned the debt of the respondent bank. Stop this application, filed subsequent to the order by which the court proposed to pronounce the orders in the writ petition is hence also disposed of in terms of the above. Stop. Next.
Item number 2. আমি করে দিচ্ছি।
Okay. You're for the state.
Yeah, for the state.
What is the matter about?
The matter is, my lord, the petitioner filed this matter, my lord. Her complaint is that she made a complaint against her erstwhile employers and, my lord, the other colleagues. Police investigated, my lord. He also, she also, my lord, complained that her mobile laptops are, my lord, hacked. But we tried our best, my lord, could not find anything. That has been pointed out before, my lord, Honorable Justice Rajasekhar Mantha. When she tried to, my lord, invade, my lord, then, my lord, the matter was, my lord, released.
Tried to?
Tried to, my lord, when her, my lord, the advocate is, my lord, the pleading, my lord, from backside, my lord, he just pushed her advocate and, my lord, come in front of her side, my lord, and started.
It's not a he, it's a she.
My lord, she, my lord. She, my lord, Dr. K.A.D.
Advocate is a he or a she?
He. And that is why my lord matter was released, my lord, on that day.
Very well. This matter has been assigned to the to this court. The matter has been assigned to this court. Stop. Next, no one appears for the petitioner. Stop. The state is represented. Stop. List this matter on. Give me a date, Mr. Ghosh, because I will ask you to inform the petitioner.
My lord, first week of May, any day, my lord. First week of May, my lord.
Why? First week of May? List this matter on 19th April 2023. Stop. Learned counsel appearing for the state is requested to communicate this order on the petitioner. Where does she stay? Baguihati.
Baguihati.
Yes, 19.
19.
Do it today. Communicate the order today on the petitioner.
Item number 3.
My lord, item number 3, my lord, I am for the petitioner. My lord, this is for non-prosecution. My lord, this is regarding, my lord, I filed this writ petition since the DRT was not functioning. Now, my lord, the DRT is functioning. My lord, I am, my lord, proceeding the matter there, my lord.
Yes, learned counsel appearing for the petitioner hands up a letter of 31/3/2023 from the petitioner, which states that the petitioner intends to withdraw the writ petition. Stop. The letter is kept on record. WPA number 7009 of 2023 is accordingly dismissed as withdrawn. Interim orders of any shall stand vacated.
Declare.
তোমার যা ইচ্ছে করো তুমি আমি কি বলার
Item number 4.
I beg to appear for the petitioner, my lord.
For the ESI authority, my lord, I have not received the
Microphone.
My lord, I appeal for the respondent in this matter, my lord. My lord, I have not
Who
received
is the
the
respondent?
ESI authority, my lord, ESI corporation.
My lord, your lordship will kindly
Come on,
remember, my lord, I had taken leave from your lordship, my lord, to move this matter today because they, my lord, in a most clandestine manner, my lord, has opened the financial bids and held a reverse auction without any intimation
What is
to
a
me.
reverse auction?
My lord, reverse auction means, my lord, where one price is set, my lord, and everyone bids below that price, and whoever comes to the lowest, my lord, will be awarded the tender. Now, my lord, on 6th April, my lord, we get an intimation. On 4th April, we get an intimation that we are technically qualified. On 6th April, we get an intimation that a reverse auction will be held, my lord, which has no details of my tender.
My lord, they have
My
not lord, participated, my lord, as I have been told.
তোমার তো
my lord,
ব্রিফ
so
নেই
far
তো
from-
তোমার তো ব্রিফ নেই এখন বলতে দাও
বলো, ঠিক আছে,
তুমি
বলো।
যখন জানো তখন টাইম
Okay,
নিচ্ছ কেন?
Mr. Bandyopadhyay, please address the court.
My lord, first he seeks time, then he interrupts.
Taking time, that's why.
Well, either he has the brief or he doesn't know the facts.
Very well. Mr. Bandyopadhyay, please address the court.
So, my lord, on 6th April, my lord, we receive an email which has no details, no connection with our tender number. It does not even say that it is for ESI Joka.
So prayer D is to hold a fresh reverse auction.
Fresh reverse auction, my lord, so that I can participate. My lord, I can contribute to, I can give it the 400 units of cooked diet for a lower price.
Prayer B is to set aside the reverse auction.
To set aside the reverse auction and hold it afresh.
And what is the urgency, Mr.
My
Bandyopadhyay?
lord, urgency is that yesterday on 11th of April, my lord, we come to know that a reverse auction has been held, and I am before your lordship saying that I have not participated, and the reverse auction list says that I am L3, and they have put a price against my name, holding saying that I have quoted 5 crores 20 lakhs. My lord, I am saying I have not participated. They are saying I have not participated. My learned friend just said that I have not participated. Then, my lord, the question, my lord, I asked to myself, how can a price be put against my name?
My lord, I have been instruction to appear.
My lord, kindly takes page
I have
106.
been instruction to appear for respondent number 2, my lord, who I have been selected for this tender, my lord, and my lord, I have just got, my client have just got that email from just yesterday 9 p.m.
What email?
Email of writ petition, my lord, of 115 page, my lord. I have not got even that Vakalatnama also, my lord. Kindly give me some time so that I can appear.
Very well.
Kind-
What is the step you're proposing to take, Microphone, please. I can't hear you.
I have to take that instruction, my lord, because just now I have received a call, my lord, that one writ petition has come.
Very well. So then, whatever you do, take it after I hear out the writ petition. All right. Whatever steps you intend to take. Since you're asking for time, I will give you that time. I will put the matter on 17th, but don't take any other steps in the meantime.
But my lord, without hearing me, my lord, your lordship will pass the order.
Get ready, come back at 2.
My lord, 2 p.m., my lord, it's lordship, kindly give me Monday, my lord.
I will put the matter on Monday. Don't take any steps, or get ready, come back at 2. Which one do you choose? Don't accuse the court of being unfair. This is one of the most fair courts you will come across.
I'm saying, my lord, without hearing me, lordship will pass the order.
I'm giving you that choice.
One day, my lord,
Get ready and
your
come
lordship
back
can
at
give me
2.
one day time, my lord. On Monday, your lordship can
Very
give
well.
it.
Learned counsel appearing for the ESI authorities seeks time. So does learned counsel appearing for the private respondent. Stop. This matter, learned counsel appearing for the petitioners had sought for leave on the ground of urgency, and leave had been granted yesterday. Stop. Next. Since the respondents seek time through counsel, it is expected that the respondents will not proceed, will not take any further steps before the matter is heard out. Stop. List this matter on 17th April 2023. Next. Counsel appearing for the respondents was also given the option of getting ready in the matter and coming back at 2 p.m. today, which counsel refused. Next.
Well, affidavit of service may be kept with the record. I hand it over to your
Service is kept on record.
Then what we will do, my lord, lordship, kindly, my lord, then just putting.
Come back at 2. Come back at 2 and get ready.
To come at 2 p.m., my lord.
Very well. Order to pass on at 2 p.m. 2 p.m.
Yes, my lord.
Grateful.
Grateful, my lord.
Let them serve a copy, ma'am.
Item number 5.
My application, my lord. My lord, we are sick. May I file my affidavit in service? My lord, my application against the Indian Oil Corporation for refund of my security deposit.
Yes.
My lord, I had
Mr. Chatterjee, microphone.
Well, Vasu.
Sorry. Vasu. Microphone.
I believe I can be heard now.
Yes.
Yes. Now, my lord, I had been a successful participant in a tender process, and I had entered into a contract for 3 years to supply 12 cars along with
12.
Not Mr. Ghosh's along
12
12 cars.
Cars.
Yes, along with drivers. For the period of 3 years that started from 1st of March 2017 and ended on 28th February 2020. Now, my lord, the subsequent extension was also given till 31st of December 2020. Now, as per
what is the relief that you want?
The relief is to release the security deposit that is with them.
What is the urgency?
My lord, without these.
The point is short, my lord. If I do,
Mr. Ghosh, what is the urgency?
Urgency is my money has been withheld.
No, look at prayer A, please.
Because I have to sell
release. Your only
assets.
prayer is release of the security deposit of 26 lakhs. Very well. And who will release this? Which respondent?
The Indian Oil Corporation.
Indian Oil Corporation. This money has been withheld since when?
2022.
20?
2021.
Microphone. Money withheld since when?
21.
21. What is the urgency after 2 years?
My lord, money, because I have to sell my other assets, my lord, in order to run my business.
If 2021 they have withheld your money, why did you file the writ petition in November 2022? You have survived.
No, Lord, the security deposit will be released after successful completion of
Mr. Ghosh.
So after 1 year. After 1 year.
After 1 year. So I can ask for affidavits, short affidavits?
Yes.
Because there is no scope for an interim order.
No.
The only prayer The petitioner's only prayer, adjunct petitioner apostrophe S, is for a direction on the Indian Oil Corporation to release a security deposit of rupees 26,90,000, which was allegedly withheld by IOC since 2021. Stop. Since there is no scope for any interim order at this stage, affidavit in opposition within? Within 2 weeks. Reply within a week thereafter. List this matter after 3 weeks. Mr. Ghosh, come to prayer A, please. What is this language? Security deposit and so deposit? What does this mean? Prayer A at page 13, 1-3. Mr. Ghosh? Security deposit and so deposit. What is that?
Some mistake.
Very well, 3 weeks.
But there is another writ petition pending, my lord, connected to this. The workers of the petitioner before your lordship has prepared a writ petition claiming equal pay for equal work. There is a prayer in that writ petition that Indian Oil should adjust the bills of the petitioner before your lordship and pay the workers. That is why this.
You're for Indian Oil?
Indian Oil, my lord. Since that writ petition is also pending.
Yes.
That is a group 3 writ petition before the filed by the laborers. They say that they are.
If it's a group 3 writ petition, how can I pull it in my court?
That is the difficulty, my lord, because the prayer is Indian Oil should pay them.
Let the writ petition proceed in accordance with its own pace. I can't pull another learned judge's matter in my court. Yes, next one.
Item number 6.
This is my writ petition. This will.
Lord, I appear for the bank.
Well, this, what happened here, your lordship had heard the matter. This is come back from division bench on remand with some interim protection.
Are you enjoying any interim order?
Yes, yes. Lordship had passed that.
This is, as I understand, it is basically
Mr.
a
Dhar,
hearing matter.
microphone, please. Yes.
Effectively, it is a hearing matter.
Hearing,
and,
hearing. Lordship has fixed it for because.
No, where is the interim order?
My lordship's order is 19th December 2022.
Very well. And you were. State of affairs as of today.
Yes. Now, while the affidavits are complete, I should not take too much time.
Mr. Mitro, you can come back on some other day if you want.
I can come. I can do it today.
You're enjoying an interim order.
Yes.
Mr. Dhar, do you want it to be heard right now?
I don't find there is any urgency.
No,
In
actually,
fact, my lord,
well, I leave it to my lord, but then there is some urgency because our may not be today.
Protected.
I can.
I should say one thing. It's
Yes.
nothing to do with Mr. Mitro, but for everyone else. I was not present in when the matter was mentioned. The reason why it was upgraded and mentioned. The reasoning which was given,
Was notice given to you?
notice was given, but my lord, neither myself nor my learned advocate was there. But because of this live, we could see the submission and the reason what was made. I don't want to go to the depth
What
of
is
it.
this new game, Mr. Dhar, that
Nothing
you
from-
don't appear for the mentioning, but you see it on live?
Eat online. This is
No,
very.
What happened that yesterday when my learned friend came
Anyway,
to me
Lordship, the
to
journey-
say that the matter might come any day, I said just check whether the matter might be there for mentioning. He from his mobile, he checked his Gmail and found there was a notice which he missed. Then I said, because of this technological benefit, you see, you notice what was the date and you can go back to that timing and you can see that. So he saw, and I have also seen. The reason what was expressed before your lordship, I don't want to say that was incorrect. Nothing.
No, I don't remember the reason. What was the reason?
They said that we, despite your lordship's order, we are pursuing something against this order. And the expression.
Pursuing something, what does that mean?
Yes, my lord, I do not know. They said that the bank is instigating the DRT. My lord, this is factually incorrect, absolutely incorrect. And
Yes, I remember
I was not.
and
the junior
lordship's
mentioning.
expression of your lordship was that then I would vacate the interim order. But I don't mind if the matter is hard out. All I want to say
Wait,
is
let-
for
let me
everyone
look
else.
into
No,
the
it is
fact.
not for Mr. Mitra or anybody else. That while
No, I don't remember Mr. Mitra or
well,
Mr.
now-
Gupta.
Mr.
during-
Mitra was not there.
Because
No.
I usually remember the faces who, which men,
It
who
was not
mentioned
Mr.
in
Mitra.
my
What
court.
was now I can see why he said there was some urgency is that here, my lord, there was a otherwise it'll take here, my lord, there's a surface sale of my property.
Yes.
I am the mortgager, they are the mortgagee. Surface sale was of the ground floor only of the building. Sale notice, sale certificate, even the section 14, everything ground floor only. But then when the conveyance was executed, the sale certificate is interpolated to add first and second floor also. First, second, third also. And the conveyance deed on the basis of the interpolated sale certificate is ground first, second, third. Even
Mr. Mitra, even if I believe what you say, which I should, because you're an officer of the court, you're protected.
I am protected.
How
So-
will the bank
No,
take any steps,
because
even
because-
if they're interpolating documents, because you're
because-
protected?
because they have now given an NPA notice to us. Because now my first, second, third floor is unsold. I would have sold it through bank only and got the money and the account settled. And now I've got an NPA notice. I find that's why possibly my and he has prepared a supplementary which was not shown. I didn't reply. Where the NPA notice has come.
NPA is dated what?
25th of February, post that order. So that's why possibly, but then, as I am saying, Lordship, I am protected. Lordship kindly keeps it any day as per my Lord's convenience.
Yes, tell me when. Yes, Mr.
first
Dhar,
is-
you suggested it. I will keep the matter on that day.
Any day.
Lordship, next week if it's possible, my Lord.
Yes, Mr. Dhar.
Next week,
20th?
20th, I cannot fix it. 19th?
19th of.
19th? Very well. Yes,
And the affidavit reply, may I keep on record?
the affidavit in reply is filed in court today. Stop. The petitioners continue to be protected by an order passed by this court on 19/12/2022. Stop. Affidavits are complete. Stop. List this matter on 19/4/2023 as prayed for.
Yes,
Lovely.
affidavit service also.
Item number 7.
My lord, I am appearing on this matter on behalf of the petitioner. My lord. This is the affidavit of service.
The IP for the state respondent.
You want your name to be recorded as a tenant?
Recorded as a tenant.
I can't hear you. Microphone, please. Yes.
My husband is the tenant of the
Microphone. I
my
can't hear you.
husband. My husband is the tenant of the.
Your husband has died.
Yes, my lord, on 2017.
Yes.
And from that date, I'm staying there with my son. At present, my son working in Hyderabad. And suddenly on December 2020, December 2022.
Yes.
When I came back from Hyderabad from my treatment, I have severe ailments in my old aged ailments. Because of that reason, I went to Hyderabad for some months. When I came back to December 2022, I suddenly noticed that my flat has been locked and sealed. And then I went to housing department and giving them a notice. Kindly look at the notice. Sorry, my lord, the letter. My lord, kindly look at the letter.
What is under challenge in the writ petition?
Nothing, my lord. He says, my lord, her husband was allotted a flat on rent.
It's a she.
It's a she, my lord.
She.
Her husband, my lord,
was allotted a flat under rent under the LIG housing scheme, my lord.
LIG
Now, my lord, I find a representation pending at page 35. Let it be considered, my lord. Let a reasoned order be passed.
You want something else apart from considering the representation?
Considering at present, my all belongings, my almirah, my bed, washing machine, TV, everything is in the flat. Gas, oven, everything is in the lock.
December 2022, but you have filed it in March.
And my lord, I made several representations to them. And also made a representation to the respondent number 3, that is the Kashipur PS, Kashipur Police Station.
And who has done this, Mr. Chatterjee?
The housing department. my lord.
Housing
Admittedly,
department.
my lord,
It's a loan matter.
my lord, possibly not, my lord. Possibly the husband was allotted a flat under a housing scheme.
Yes.
Now, for some reason, my lord, record reveals, my lord, the housing department has called upon the petitioner more than twice to attend hearings. They have failed to, their representation says so, my lord. They have failed to do so. Finally, my lord, their representation admits that it was sealed by the housing department in the year 2022. Now, my lord, they want that seal to be broken and, my lord, the
Use the flat.
flat to be handed over to the petitioner. Let the representation be considered at an early date, my lord.
You do it in 1 week, Mr.
My lord,
Chatterjee.
we will.
In 1 week, because if she has been locked out.
My lord, absolutely, my lord.
1 week.
Only thing, my lord will then kindly fix a date because, my lord, we need to give a hearing to the petitioner. That will be
Give
fair.
it
my
in
lord.
the 1 week, in the coming 1 week, and decide.
She is ready.
Yes. How old are you?
66 years. Sorry, my lord, that is 63 years.
Very well.
My lord will kindly give us 10 days, my lord. We need to give notice to her. That is the difficulty, my lord.
Let the council know now.
My lord.
Hold the hearing tomorrow and decide in 1 week. What is this?
Tuesday, my lord.
Why 10 days?
Tuesday, my lord will fix it.
Inform the council now of the date of the next date of hearing and hold the hearing. Yes, the petitioner is a senior citizen and has been locked out of her home since December 2022. Stop. The petitioner is a widow of her and her deceased husband was the tenant of the what is this? It's a housing society.
LIG house.
LIG housing scheme, my lord.
Of a housing scheme in
Under the
in Kosipur. COSSIPOR. Is that the place? Kosipur.
Kashipur.
Kashipur.
COSSIPORE. Comma Kolkata. Stop. The state respondents are represented. Stop. The records include a representation made by the petitioner through her advocate to the estate manager, comma housing department, comma government of West Bengal on 4/2/2023. Stop. The learned counsel appearing for the respondents proposes that the submits that the petitioner could not make herself available for several of the hearings held by the state respondents. Stop. Next, whatever be the case, comma, the petitioner is entitled to know the reason for the step taken by the respondent and is also entitled to a minimum level of convenience. Stop. WPA number 5944 of 2023 is disposed of with the direction on the
Respondent 2.
Respondent number 2 being the
Deputy Secretary Housing Department.
being the estate manager,
estate manager,
comma estate direct. That's the one, Mr. Chatterjee. Being the estate manager, comma
estate directorate.
estate directorate, and ex officio deputy secretary, dekhe nebe, comma, housing department, to consider and dispose of the representation within 21st April 2023, within 24th April 2023, stop. Needless to say, comma, the petitioner shall be given a hearing before the concerned respondent
Can we
passes a
fix
reasoned
with the consent of the parties, Madam, can we
Yes.
fix the date to be 18th?
before the
18th.
before the ki bola?
Yes, Madam.
Before the concerned respondent passes a reasoned order, stop. The concerned respondent shall also hold a hearing on 18th April 2023 as suggested by learned counsel appearing for the parties. Stop. A copy of the reasoned order shall be made available to the petitioner by 26th April 2023. By 27th April 2023.
Since your lordship was not invited for affidavit.
This court has not gone into the merits of the case.
My lord, I want to add one thing. The petitioner went to the housing department on the February 22. My learned friend has said they are not representing them in the hearing process, but she went to that place.
Could not make herself available for the hearing. Yes, next.
Item number 8.
I'm for the respondent bank.
I am for
What
the
is the
petitioner,
can
my
for?
lord. I am for the petitioner.
What is the can for?
Can filed by my
My
lord.
lord, may I be permitted to file the
What
affidavit?
Is
in
that
opposition?
interest rate?
Yes, my lord.
Or recalling the interim order passed on
29th of March.
recalling the order dated 29th March.
Yes.
That is at page 24 of the application, my lord.
Let your learned friend place it. It's her application.
My lord,
Page?
24 is the impugned order, my lord.
Yes.
My lord, this difficulty, the entire thing is, my lord, this RLLR rate, which is the repo linked lending linking rate, this is variable as per the RBI guidelines, my lord. This will vary, and as it varies, the rate of interest fixed by the bank shall also vary. Now, this is the difficulty is, my lord, this is system generated. The bank cannot manually do any adjustment because it is done, the rate fluctuates, it increases, and the board of directors have to consent to it. So a lot of
board of directors
of the bank, they have to give to consent. Suppose if I decrease that rate, then I have to seek permission from the board of directors of the
So
bank.
now it's 9.4.
9.40. Now, my lord, his only
the RLL rate.
That is the current rate, my lord. His only grievance is with the rate of interest, which is misconstrued in the sanction memorandum. I shall place one by one, my lord. That was 6.70. Now, my lord, this 6.90 minus that concession which the bank gave him, that was 0.20. So that minus 6.90 minus 0.20, so 6.70 was that at that time it was fixed. Now it is 9.40.
So he was given a concession of 0.20.
That will be applicable for 3 years from the date of taking that loan. But my lord, this 6.70 will not remain constant. Now, my lord, now presently it is 9.40. He's entitled to that benefit of 0.20. Which is valid till 2025. So now it is 9.20, my lord. Now, my lord, if your lordship kindly takes my affidavit in opposition, my lord.
The affidavits are complete in the writ petition.
My lord?
Affidavits are complete in the writ petition.
Yes, my lord, everything is
No,
there.
then why have you filed a can then? I'm
is-
hearing out the writ petition then.
Yes, my lord.
Yes.
The if your lordship kindly takes the affidavit in opposition, my lord.
Yes.
My lord, the main agreement, the housing loan agreement, is at annexure 01, page 11, my lord.
Yes.
Now, my lord, here at page 14 of the same agreement, this breakup is there at point number 7. Page 14, my lord, point number 7.
Yes.
The borrower shall pay interest at 6.70%. Concessional ROI as per
there's a 6. Where is a 7?
7, my lord, there's a, point, this numbering is not
Yes,
visible.
so how will I know where is 7?
After, just the paragraph after 6, my lord. It should be 7. That number is somehow missing.
Yes.
I find. The borrower shall pay interest at 6.70% concessional ROI as per Circular 839 by 2021. That is in brackets minus 0.20. So here, my lord, the breakup is given. This is the original agreement which he has signed. So he was aware of this concession and the rate, and the concession is 0.20, my lord. Now, my lord, here in the same agreement, my lord, page.
No, so he was, what was he aware of? He was just aware that he has to pay interest at 6.7%.
He was aware of that. So the concession which he's saying that
Yes.
I'm entitled to, that concession is only restricted to 0.20, my lord.
Yes.
Not that the 6.70 will remain prevalent throughout the tenure. Now, my lord, page 21 of the same agreement, my lord, it classifies the rate of interest as floating, my lord. It's clearly written here. So he is aware that the rate is floating. It's not fixed.
Where does it say floating?
My lord, page 21 of the main agreement, my lord.
Yes.
Here, point number 3, it's categorically written as floating.
Yes.
Now, my lord, my next document that I rely on is annexure O2. This is the master circular, the RBI guidelines, my lord.
Yes.
My lord, that's at page 22. Point number 2, my lord.
Yes.
Point number 2, my lord, the last 4 sentences of that paragraph, my lord.
Yes.
May I read out, my lord? Based on the consultations with stakeholders, it has now been decided to link all new floating rate personal or retails, which include in brackets housing and auto. His is housing loan. And floating rate loans to micro and small enterprises extended by bank with effect from October 1, 2019 to external benchmarks. Accordingly, point number 3, my lord, accordingly, RBI instructions contained in Master Direction on interest rate on advances issued by DBR DIR number so-and-so dated March 3, 2016 are amended as under. My lord, 3.1 of the RBI circular, the existing paragraph number 7 of the aforesaid Master Direction stands replaced as under. Now, my lord, this is relevant. Point A. All new floating rate personal or retail loans, which is housing and auto, and floating rate loans to micro and small enterprises extended by banks from October 1st, 2019, shall be benchmarked to the one of the following: Reserve Bank of India policy repo rate.
Yes.
So here it is clearly stated, my lord. This is the circular I'm relying upon. This is the RBI circular, my lord. Now, my lord, at annexure O3, page 26, my lord, his statement of accounts is there. From time to time, every 17th of the month, as per the prevailing rate, his account is auto-debited.
Yes.
And my lord, on page 27, I've also annexed the current rate, my lord. 9.40 is the current RLLR rate. So he's getting that discount, which is 0.20%, and now he's paying 9.20%.
Why was the writ petition filed?
He wanted to pay the rate as 6.70.
No, apart from that?
That was the only grievance. And my lord, the last, now, my lord, I shall place this document, my lord. The main writ petition, my lord, annexure P2, page 24. This is the sanction memorandum, my lord, dated 16th March 2022.
Yes.
My lord, here, point number 8. Here also it is clearly written.
Yes.
My lord, point number 8, this states ROI, chart CRP. CRP is the credit risk premium over RLLR rate.
What is ROI?
ROI is the rate of interest.
Very well.
charged over CRP over RLLR. CRP is the credit risk premium.
Credit risk.
Yes, my lord, credit
Yes.
risk premium.
Yes.
Over repo linked lending rate, that is 6.90% minus 0.20% as per circular so and so, my lord. The ROI of the present proposal, it is written, is at the rate 6.70%. Now, my lord, thereafter it is clearly mentioned the interest rate is linked to RLLR. The RLLR and the actual lending rates are subject to review and variations from time to time as per RBI guidelines, and also subject to any changes in the financials of the borrower. The changes in the RLLR and the actual lending rate will be notified in the notice board of the bank from time to time, and also in the bank's website, which shall be
Very
construed.
well. I understood.
Change
The
of this
prayer at page 19, what does it say? Prayer A.
Prayer A at page 19. My lord, that one clause, my lord, he has relied upon in the sanction memorandum, clause M, that here this is some mistake of the bank of the erstwhile officer must be, because there the original agreement they have the breakup. There it is 0.20% has been stated, but he is relying only the misconstruction of this sentence, my lord, he is banking
No,
on.
the prayer A is in terms of sanction memorandum and
Yes, my lord,
deduct
the clause M of that sanction memorandum.
and deduct the monthly installment to the tune of rupees 96,286. What does this mean? That he wants the interest rate to remain at 6.7.
70. That is the only thing he's, which is next to impossible, because that is not the prevalent rate, my lord. And
Yes.
that is the only thing he's saying. This he's relying on. If your lordship kindly comes to the sanction memorandum once, my lord, page 26. That clause M, some mistake on the. I don't know. This is some mistake. The language itself. The concessional rate of interest, that is 6.70% in the bracket.
Yes.
The concession, it should have been concession, which is 0.20%. That should have been stated there. He made this writ petition entirely out of this one sentence. He said that this is what the bank is agreeing on, that I'm entitled to 6.70% throughout my tenure. That is not a fact. And he has signed the original agreement. He should have known. Clearly, it is written floating. Clearly, it has been mentioned that 0.20% is the only concession he is entitled to for the next 3 years. The rate of the interest cannot remain fixed. And that has been communicated to him by our
Very
advocate
well.
also.
You have filed the reply.
I have.
You have filed the reply. Affidavit reply.
Yes.
I haven't received a copy, my lord. He has not served me.
You haven't served the reply.
No. Yesterday I have affirmed the.
Very well. I will keep the matter on Monday and pass the order on the vacating application and the writ petition. All right.
My lord, one difficulty, Monday, my lord, the amount will be auto-debited from his account, my lord. So
Very well. But the Monday is the only available date. I will pass the order on Monday.
Great.
It appears from the submissions of learned counsel appearing for the parties that the petitioner has not served the affidavit in reply
I am
to the
just-
bank. Stop. This has been handed over only after at the time of dictating this order. Stop. Next, the respondent bank has also filed an application for vacating an order passed by this court on 29/3/2023. Stop. List this matter on 17th April 2023, which is the next available working day, for passing necessary orders on the vacating application as well as in the writ petition. Stop.
I beg to leave to file reply.
What? Yes, the affidavit reply is filed in court today.
grateful, your lordship. My lord, should we hold? We cannot hold back, so the amount will be auto-debited, my lord.
That is up to you. I can't advise you.
Grateful, your lordship.
Yes. এটা উপরে রাখবে আমার পরের দিন এটা লাগবে অর্ডারটা দিতে এই যে ঠিক করে দিয়েছি ওকে yes
But, in this matter, your lordship has heard it. my lord.
call on the matter please
Item number 9.
I am for the petitioner. My lord, this matter has been heard by your lordship. My lord, there was a direction to file a supplementary written notes of argument. my lord.
yes because I could not understand
Yes,
what
my lord.
you did.
My lord, I
Yes.
have prepared one.
But our notes we have submitted earlier, Lord.
This is only in respect of. your
I hope I
lordship's
can
query.
understand your note now on a second reading. Yes. দেখো তো রেসপন্ডেন্ট নোটটা আছে কি Yes, learned counsel appearing for the petitioner had been requested to file supplementary note explaining the queries raised by the court on the last occasion. Stop. The supplementary note is filed in court today. Stop. List this matter on 21st April 2023.
Grateful, Lordship.
Item number
I had
10.
argued, my lord. Respect. Pass it over for Mr. Abhijit Mitra was supposed to reply or give his reply.
You have finished, Mr. Rahim?
Lord, I have finished, my lord, except for that one judgment which I wish to give, my lord.
Yes.
Lord,
what
would
is-
your lordship then keep? Would your lordship then keep it for Monday, my lord? I would like to, my lord, come and, my lord, appear physically and just finish the last leg of my arguments, my lord.
List this matter on
If it is
17th April 2023 as prayed for on behalf of the petitioner by learned counsel appearing for the petitioner. Next.
greatly obliged.
Item number 11.
Item number 11, my lord, I appear on behalf of the petitioner. This is, my lord, that matter, my lord, where, my lord, I have challenged, my lord, the inaction on the part of the SFIO. I filed a writ petition here, my lord. Then I filed 3 writ petitions in Gujarat High Court.
Yes.
For
Yes, I remember.
yes. Now, Lordship says I have made 2 CAN applications. Lordship says before I consider your CAN application, you have to satisfy me about the jurisdiction of this court.
Yes, Mr. Kundalia, just in one line, tell me what your submission was on the last occasion. I remember some of it, but not all. Yes. Yes.
Doctrine of finality of order.
Yes.
And I have judgments on that point also, my lord. Lord, but before that, Lord, I've prepared one chart.
Mr. Kundalia, give a copy to your
Hi.
learned friend also. Yes.
Lord, these are the proceedings that are there. This chart is of all the proceedings and the prayers. My lord will kindly peruse this chart.
So there are 4 proceedings.
I have here shown 3 proceedings.
Three
There's,
proceedings.
no, there are two writ petitions and two cans.
Three writ petitions. First and second are the ones that are before the Calcutta High Court, which is the first one, my lord will see, is also listed in today's cause list. The second one is this matter, which we are
No, the first one is 29738. Which is that?
29738 is also appearing in my lord's list.
Very
Okay,
well. Yes.
that is there.
36007 is what I'm hearing.
3607 is what is being heard, my lord.
Yes.
In 3607, can 1 and can 2 prayers are there, my lord. These are the two charts, two columns. And the final column is of Gujarat High Court writ petition, which was disposed by the single bench, which was upheld by the division bench, and against which they say that they have gone before the Supreme Court. So
No,
these are
the last column just says special civil application. That is the last column.
that is how they number. No,
In the
nomenclature
Gujarat
of
High Court?
Gujarat High Court. Yes,
Special civil application. This is Gujarat High Court.
yes, my lord.
So 14430 is Gujarat High Court.
Gujarat High Court.
Yes.
So my lord will now kindly
So
see
there are three proceedings.
three proceedings. I'm not going into the other proceedings that he's talking about in Gujarat. I'll restrict myself to these three proceedings.
Mr.
And
Kundalia,
Gujarat proceedings has attained finality, my lord. That is my respectful submission.
the second and third pages are what?
Same
Continuation.
prayers, all the prayers.
So in future, Mr. Kundalia, if you do something like this, then you must repeat the heading in the second, third pages also.
My lord, I will do that. I will.
It's just more
Henceforth
clear.
I-
It's much more convenient.
Henceforth
Yes.
I will do that, my lord. So this is the continuation of all the prayers. So my lord will see, before I go into the chart, short facts, my lord.
Yes.
Now Gujarat NRE Coke went into liquidation
Yes.
sometime in 2016.
Yes.
Sometime in 2018, SFIO was specifically given 2019 specifically directed that investigation needs to be taken. Now, post that, SFIO comes and sends summons to the directors. There's a expected fraud. Consequent to that, they appear. Out of the two petitioners, one petitioner was called. Apart from all the other employees, etc., they have been coming. Now, IRP was also appointed in the NCLT. Consequently, they stopped appearing from, the petitioner number 2 stopped appearing from 2019. Now, thereafter, there was a
Petition number 2 is the man or the woman?
the man.
The man.
Woman actually is not, we have never summoned her at all.
Yes.
It is throughout the gentleman, the petitioner number 2.
Yes.
Now, in 2019, there was a search here in Gujarat NRE premises.
Yes.
Certain documents were seized. They have also given documents. The IRP has also forwarded certain documents which go to more than a terabyte of data. Thereafter, my lord, they file a writ petition here before
So
my
that means lot of data or not that much data?
lot of data. Lot of
Yes.
data. Lots of data, my lord. So consequently, a writ petition was filed before this honorable court. Writ petition, the interim order was not passed. Affidavits were completed. And thereafter, they went before the Gujarat High Court. A few days later, they went before the Gujarat High Court. Now, Gujarat High Court, they challenged the summons as well as the investigation. Here, they challenged the investigation process. Now, in the Gujarat High Court, order was passed and they even gave an undertaking that they are going to appear. They, as in the petitioner number 2, will appear before the authorities in Delhi. They did not appear. Thereafter, they filed separate applications even after that, and consequently, the judgment was passed by the single bench. Against that judgment, the division bench came in, where both the powers of the investigation as well as the summons were adjudicated and a decision was passed. Now, the moment that happens, he files a CAN application here before my lord on the same cause. He also at that point of time before the Gujarat High Court says that I want to appear via video. That was also refused. Here that is not the case, my lord. Here he has gone and said that this is bad, and he has said the report that is there ought to have been filed. The other prayers in the can are that you kindly inform how long will this take? How long will this investigation take?
And he's given up, Mr. Dev has given up his prayer of the video conferencing.
Today, Mr. Dev, on the last occasion, has given up on mostly everything. He merely says that I want to appear before the authorities, but allow me some concessions. This is what Mr. Dev is saying today, knowing the position, because, my lord, apart from this writ petition that is there,
What is the concession he's wanting?
he probably wants that
A
time-bound thing and video.
But Mr. Kundalia, what is wrong with that? If I direct you to proceed against the petitioner in a time-bound manner, finish the investigation within a certain
No, my
period
lord,
of
it is
time.
not possible to finish this investigation in such a time-bound manner. The reason being the voluminous documents that are there, and the sensitization, as well as specific investigation and inquiry on these documents from several parties. What has happened? What has become very urgent for him today is, because he was not coming, so many other employees have been summoned and they have started coming in. So suddenly, why suddenly he comes before my lord and says it is urgent? He has not been called.
Not been called?
As of now, has not, from past July 2022, he has not been called. Since he has not come, he has not attended to the summons, even after the division bench.
So you're saying that to refute the evidence given by his employees?
Yes. Yes. Today these employees are coming. Employees are attending to the summons. Today suddenly he feels that he is getting trapped.
So Mr. Kundalia, even if I were to agree with you, why are you saying that it is not possible for you to conclude this in a time-bound manner? Which you're probably expecting that I will say you do it in 1 month or no. I will give you that reasonable time, whatever is reasonable according to you.
My lord, this was the point that was taken up by the Supreme Court in a matter called Rahul Modi, where it was said now 212 gives the report can be given according to Rahul Modi. The report can be, there's no time limit for the report. But if the central government wants, central government can ask for an interim report, which could be within a period of 6 months, etc. Now, in this case, that is not the case, my lord. Today, initially, a report was sought for 6 months, and thereafter there have been extensions, and there is no specific, the central government in its understanding has not given a specific direction for an interim report on investigation. So, my lord, today it is going absolutely as per the provisions. And considering the enormity of the data and the enormity, probably, we will not say that there is fraud. We will not say there is fraud, because it is under investigation, and that investigation requires some time, my lord. So, my lord, today, if my lord gives a specific period of time, say 6 months or 1 year also, that may also curtail the time limit. Unless my lord feels that if I am unable to finish it within that time, I may be given a liberty to come before my lord and take an extension.
That really amounts to indefinite time. If I give you that leave, you will come and say that no, we could not. And if you say, Mr. Kundalia, that even 1 year is not enough, then that's a serious business.
My lord will kindly see the section, and my lord will kindly see the
Section?
judgment also.
Or which act?
The Companies Act, my lord.
Lord, I don't want to interrupt, my lord. I will show you the initial order permitting them to proceed. That was for a period of 6 months only.
Very well. Mr. Dev, I will
Yes.
come to. Yes.
My lord will kindly see 200, section 212. My lord, may I place just a
Just 1 minute, please. Section 212.
212, my lord.
Yes.
My lord, may I place a small part of it? Without prejudice to the provisions of section 210,
Yes.
where the central government is of the opinion that it's necessary to investigate into the affairs of company by the Serious Fraud Investigation Office on receipt or report of the registrar, which is there, my lord, or
Yes.
inspector under section 208, on intimation of a special resolution passed by a company that is affairs, this is not the case, on request from any department of the central government or a state government. In this case, it is A. The
Mr.
central government may,
Microphone, please. Yes.
the central government
Yes.
may by order assign the investigation into the affairs of the said company to the Serious Fraud Investigation Office, and its director may designate such number of inspectors as he may consider necessary for the purpose of such investigation. My lord will may also place the second one, and thereafter I'll go to 10 and 11. Where any case has been assigned by the central government to the Serious Fraud Investigation Office for investigation under the Act, no other investigation agency of central government or any state government shall proceed.
You're placing which one?
Hello, two.
Two.
Yes. So this investigation is given much more importance than any other investigation that is going on against this person, my lord, which
Yes.
is why it is in our interest to finish this as fast as possible. My lord will kindly see 2, where any case has been assigned by the central government to the Serious Fraud Investigation Office for investigation under this Act, no other investigating agency of central government or any state government shall proceed with investigation in such case in respect of any offense under the Act, and in case any such investigation has already been initiated, it shall not be proceeded further with and the concerned agency shall transfer the relevant documents and records in respect of such offences under the Act.
And doesn't give an outer time limit for this investigation?
No, my lord. The outer time limit is the only, if the central government deems it fit to seek an interim report. In this case, my lord, the central government has not sought for an interim report. Central government has asked for the investigation and give the report. And there's no specific time limit that is given. My lord will also see to the subclause 10 and 11.
Yes.
No, 11 and 12, my lord. 11 says, the central government, if so directs, thus the Serious Fraud Investigation Office shall submit an interim report to the central government. Next, on completion of the investigation, the Serious Fraud Investigation Office shall submit the investigation report to the central government. So there is no specific time limit on this point, my lord. My lord will kindly see 2019 5 Supreme Court cases, 266. Serious fraud investigation versus Rahul Modi and another.
What did the Supreme Court say? That no time limit needs to be framed.
My lord will kindly see from paragraph 30 to 34. ওটা annexed আছে আমার affidavit annexed আছে রাহুল affidavit.
Which page is that?
My lord, paragraph 30.
Which page?
Inner page 27, my lord. আচ্ছা আচ্ছা রাহুল মোদি আছে একটা দেখো
607 126 is not there.
Yes. Yes.
My lord, may I place paragraph 30? The investigation report under subsection 12 is to be submitted on completion of the investigation, whereas report under subsection 11 is in the nature of an interim report and is to be submitted if the central government so directs. In the backdrop of these provisions, we must now consider whether the period within which a report is contemplated to be submitted to the central government under subsection 3 is mandatory and what is the scope and extent of such stipulation. It must also be stated here that the provisions of section 43 subclause 2 of the 2008 Act do not postulate any such period, and the assignment in the present case to SFIO was under the provision of 2013 Act as well as under the 2008 Act concerned. Section 212 subclause 3 of the 2013 Act by itself does not lay down any fixed period within which the report has to be submitted. Even under subsection 12, which is regarding investigation report, again, there is no stipulation of any period. In fact, such a report under subsection 12 is to be submitted on completion of the investigation. There is no stipulation of a fixed period for completion of investigation, which is consistent with normal principles under the general law. For instance, there is no fixed period within which the investigation under the Criminal Procedure Code must be completed. If the investigation proceeds for a longer period, under section 167 of the code, certain rights may flow in favor of the accused. But it is certainly not the idea that in case the investigation is not over within any fixed period, the authority to investigate would come to an end. Again, subsection 2 of section 213 of 2013 Act does not speak of any period for which the other investigating agency are to be hold their hands, nor does the provision speak of any retransfer of relevant documents and records from SFIO back to the said investigating agencies after any period of occurring of an event. For example, under section 6 of the NIA Act, the agency can be directed by the central government to investigate the schedule offence under the NIA Act, and where such direction is given, the state government is not to proceed with any pending investigation and must forthwith transmit the relevant documents of the records to the agency. But under section 7 of the NIA Act, the agency may, my lord, I'll skip this now. My lord, will kindly come to paragraph 33. The very expression assigned in section 212 subclause 3 of the 2013 Act contemplates transfer of investigation for all purposes, whereafter the original investigating agencies of the central government or any state government are completely denuded of any power to conduct and complete the investigation in respect of the offences contemplated therein. The idea under the subsection 2 is complete transfer of investigation. The transfer under subsection 2 of section 213 would not stand revoked or recalled in any contingency if a time limit is constituted and contemplated within which the investigation must be completed. Then logically, the provisions would have dealt with it. Next paragraph is most important, 34. Yes. It is well settled that while laying down a particular procedure, if no negative or adverse consequence are contemplated for non-adherence to such procedure, the relevant provision is normally not taken to be mandatory and is considered to be purely directory. Furthermore, the provision has to be seen in the context in which it occurs in the statute. There are three basic features which are present in this matter. One, absolute transfer of investigation. Two, for the completion of investigation, subsection 12 of section 212 does not contemplate any period. Subsection 11 of section 212, there could be interim reports as and when directed. In the face of these three salient features, it cannot be said that the prescription of period within which a report is to be submitted by SFIO under subsection 3 of section 212 is for completion of period of investigation, and on the expiry of that period, the mandate in favor of SFIO must come to an end. If it has to come to an end, the legislation would have contemplated certain results, including retransfer of investigation back to the original investigating agency, which were directed to transfer the entire record under the subsection 2 of section 212. In the absence of any clear stipulation, in our view, an interpretation that with the expiry of the period, the mandate in favor of SFIO must come to an end will cause great violence to the scheme of legislation. If such interpretation is accepted with the transfer of investigation in terms of subsection 2 of section 212, the original investigating agency would be denuded of the power to investigate, and with the expiry of mandate of SFIO would also be powerless, which would lead to an incongruous situation that serious frauds would remain beyond investigation. That could never have been the idea. The only construction which is possible, therefore, is that the prescription of period within which a report has to be submitted by the central government under subsection 3 of subsection 2 and 12 is purely directory. Even after the expiry of such stipulated period, the mandate in favor of SFIO and the assignment of investigation under subsection 1 would not come to an end. The only logical end as contemplated is after completion of investigation, when a final report or investigation report is submitted in terms of subsection 12 of section 2 and 12, it cannot therefore be said that in the instant case, the mandate came to an end on 19/9/2018. So, my lord, in this case also, investigation is continuing. His prayer is this investigation should be time bound and it should be completed within a particular period. That is what he is saying today. Now, today, can he dictate that, my lord, in the light of this judgment? My lord, that apart,
Mr. Kundalia, the decision which you placed, that was where the Supreme Court was considering whether at the end of a period not contemplated under section 212 of the Companies Act, whether the SFIO would be denuded of its power to continue with the investigation. So Supreme Court said that no, you can't come to such an interpretation because A, 212, 2 and 3, 11, 12, whatever, they don't mention any period. And 2, that would be doing violence to the act, because for the purposes since under 212, the entire investigation is given by the central government to the SFIO. But here, Mr. Kundalia, the question is slightly different. I'm not saying, the court is not saying even for a moment that the SFIO will not have the authority to act if the SFIO proceeds beyond a certain period. No, I'm asking you, since I will hear Mr. Dev on it for 1 minute, if an order was made that the investigation sometime in 2018, that the investigation will be complete within 6 months, sorry, then in 2023, why will you not be in a position to tell the court,
my lord,
that I will complete the investigation even in another 6 months?
My lord, that is where my lord also has to see from 2019 December till 2023, this writ petitioner has not cooperated at all. And he has been the director, he has not been coming.
Mr.
So, my lord, for the past 4 years.
Needless to say, I will record that. And I will also say that if the writ petitioner continues with his non-cooperative attitude or not with his lack of cooperation, then he will suffer the consequences of the order.
My lord, that has been said by Gujarat also. This is what Gujarat has said.
Very well. So if the writ petitioner does not cooperate, then I cannot impose a time limit on you, because if the statute doesn't say it, I cannot say you have to complete.
My lord.
I will also make it clear that if the writ petitioner does not appear on the scheduled dates of hearing or whatever, then the investigation time will extend.
My lord, that has been said by Gujarat also. This is exactly what may I place the Gujarat division bench judge. I had handed over that copy on the earlier day.
Yes.
So that apart, my lord, I will place 3 more judgments on the doctrine of finality of order. And once I place this.
Finality of order of the Gujarat High Court Division Bench.
Gujarat High Court Division.
My lord, SLP is pending.
I have it, Mr. Kundalia. SLP is pending from the Gujarat High Court Division Bench.
That order which is relying on doctrine of finality.
We are not. Which doctor? Which I will allows me to place my judgments in my own way, and then my lord will.
Mr. Kundalia, you're going to place paragraph 18.
Yes, my lord. I will place paragraph 18.
Mr. Kundalia, I remember paragraph 18.
18.
You just tell me what the point is. That's all.
The Gujarat High Court has specifically said that he ought to have appeared. He did not appear.
Yes.
Gujarat High Court has specifically said that there cannot be any stay of any investigation, which is why Gujarat High Court has said that you go and appear. Gujarat High Court has said this in 2021, which has been upheld in 2022. Thereafter, summons were given. He didn't appear. So from July till now, he doesn't appear, and suddenly he feels it urgent to come before my lord and presses the CAN application. Now, he doesn't say, at least I was not there at that point of time. I don't know on what basis he comes before my lord, says that there's urgency of hearing this matter. My lord, that is one. Gujarat High Court also denies him the right of appearing on video.
That's
Now-
not right. He's not asking for video.
No.
Yes.
Now, so there were two things that were there.
Mr. Kundalia, now there's only one thing he's asking for.
Time limit. Time limit was something which was asked before the Gujarat court also. That was refused. One. Gujarat High Court has also looked into Rahul Modi and formed an opinion based on Rahul.
Yes.
And they had also sought for quashing of the proceedings. Quashing non-interference is there here also, was there before the Gujarat High Court also, my lord. Absolutely same. My lord, on this point, my lord, I will place two judgments, my lord. On constructive res judicata. My lord, this is a full bench judgment of
But,
the
Mr.
Supreme Court.
Kundalia, I will consider all this, but is it not in your interest also to proceed with the investigation?
Yes, my lord.
Why would you keep it hanging fire?
That is what my submission was also. It's not that we are sitting on the investigation
Very well.
for the
So
sake of
from
sitting.
2018, if it has started, today we are in 2023. Why will you not proceed and?
So may I only suggest this much, my lord? When my lord puts a time, my lord says that within this period, if possible, as expeditiously as possible.
What is the period which you suggest is reasonable, according to you?
May I just my lord although without instruction, my lord may say 6 months, as far as expeditiously as possible in that manner.
And what will you do after 6 months? You will come and ask for an extension?
No, it is that is provided he cooperates, because the documents have to he has to come several times.
And what happens to the writ petition?
The writ petition will be disposed of, my lord, because the writ petition ought to be disposed of on this ground, on the doctrine of finality. It's barred by res judicata. The points that are taken before my lord are the points that are taken before, and look at the conduct, which is why I brought in this chart. There's another writ petition that is pending before my lord, and their action can't be such that there would be multiplicity of proceedings and stalling of proceedings in this manner. My lord will kindly see the chart just once.
No, Mr. Kundalia, I've seen everything.
My lord.
I've seen the chart. I've completely understood your point, and I'm with you on that. That 2 writ petitions filed in this court,
identical.
1 in Gujarat High Court, 2 CAN applications in those 2 writ petitions.
And
before
2
this
writ
court.
petitions here.
Yes. And of course, I will not give the petitioner a free runway that you will and put a gun to your head that you will have to complete this proceeding. That is subject to the petitioners assisting and cooperating, assisting you and cooperating with you.
Yes.
Absolutely that. What is it? So many judgments. What is this? What is this on?
Or may I, my lord, come back on the time instruction? Because I need to.
You want less than 6 months?
I might be wanting more than 6 months, because I really don't know unless they tell me.
Who is they?
The officers, the SFI officers.
Not in court today.
Not in court today, but they are represented through their legal counsel from their office.
That's up to you. I can't force a time limit on you.
My lord, at least hears me on the point of maintainability, allows me to place the judgment. Just 2-3 judgments I will place, my lord. Thereafter, I will, on the next day at best, I will come.
What is now pending before the Gujarat High Court?
Nothing is pending.
Nothing.
No. Nothing is pending before the Gujarat.
And you
High
want
Court.
the writ petition to be dismissed on the ground of?
Constructive res judicata, my lord. It's barred by res judicata
Very well.
and on the doctrine of finality. My lord will.
Mr. Kundalia, how many judgments do you have?
I have 3 judgments. Only I'll just 2 or 3 paragraphs. nothing.
Just give me the paragraph. Don't
I'll,
please.
I'll only give the
Only
paragraphs.
give me the paragraph numbers, please.
My lord, I have handed over 1962. AIN 1961 I have handed over, my lord.
Yes.
My lord will kindly see paragraph 9, 10 and 18.
On which point? Constructive res judicata.
Constructive res judicata. This is the mother judgment, my lord, Daryao. Now, my lord will kindly, in paragraph 18, although it is written 18, there's a misprint here in this judgment, in this SCC printing. 18 comes after paragraph 10. So there is no 11 to 17 in this judgment, in this publication.
Yes.
So my lord will kindly see, or my lord allows me to hand over the Manupatra judgment, I can hand that over. Otherwise, my lord, it
SCC
is.
online doesn't have paragraphs 11 to 17.
No. The numbering is wrong. The judgment is complete.
Very well. So which is paragraph 18?
Paragraph 18 is paragraph 18. There are no 11 to 17 there. After 10, 18 comes in. My lord, kindly see it once.
Yes, I've seen it.
It's not that 11 to 17 are missing. And this is the alternative copy, my lord, of the Manupatra publication, my lord. My lord, I rely on 9, 10 and 18.
Yes.
My lord, I rely on, constructive res judicata.
Very well.
Thereafter, I rely on 9, 10 and 18. 62. 62. My lord, the next one that I rely on is AIN 1965, Supreme Court 1150.
Relying on Daryao.
I'm relying on Daryao. This is Devilal. This is Devilal Modi versus sales tax officer. I rely on specifically 4, 5, 6, 4, 5, 6, 8, 9, 12 and 13. And with specific stress on paragraph 8 and 9, my lord.
This is also on the same point.
Same point, my lord.
Same judge also.
Yes, my lord. I think it 11, 12.
Yes.
But the third judgment is Amatade. Third judgment is 2011, volume 3, Supreme Court cases 408. I rely on paragraph 20, paragraph 11 to 13. 408. And 16 to 25. This is with regard to applicability of constructive res judicata also on writ petitions. And 23 specifically deals with how in such situations where similar kind of writ petitions are filed in different courts, it's an abuse of process of court.
Yes.
Hello, these are the 3 judgments. And one more judgment I want to rely on.
I don't know, Mr. Kundalia, why are you laboring so much with judgment? Just tell me a time within which you will complete the investigation.
My lord, may I come back at 2?
2.
2.
Up to you.
My lord, I will come back at 2 on this specific instruction.
No more judgments.
One judgment I have that's about, just to satisfy myself, because a question might come in that this writ petition has been filed here first and the writ petition there is subsequent.
No, which one was filed first?
The writ petition here was filed
Calcutta.
first, and the
Yes.
writ petition in Gujarat was filed. So now, in this judgment, it has been said that where there is no question of jurisdiction. Now, they have not taken the point of jurisdiction either there or here.
They live in Ahmedabad.
They, as in Ahmedabad. They haven't taken it in Ahmedabad nor here. Now, if there is even erroneous jurisdiction, then the one that has been filed earlier will also come within that will be treated as, the second one will be treated as the one that gets finality first, and the second one will be treated as res judicata. My lord, I will rely on paragraph.
So the court which has jurisdiction will be treated as the first
My lord.
proceeding.
Where the proceedings have attained finality first will be treated as the first one. Even if the proceedings have been initiated later, that one will be considered as the first one. My lord, I rely on paragraph 34.2.1. Only that paragraph, because this is again a very lengthy judgment. These are the judgments I rely upon, and my lord allows me to come back at 2 with regard to the.
No, I need to process all this. You come back on Monday.
I'm grateful, my lord.
Yes. Learned counsel appearing for the SFIO has placed section 212 of the Companies Act 2013 and several judgments on constructive res judicata and on abuse of and finality of orders. Stop. List this matter on 17th April 2023 as prayed for.
Would your lordship, my lord, hear me for 2 minutes or
On Monday.
Monday?
I'm grateful, my lord.
Item number 12.
Lord, I appear for the petitioner. Lord, I was on my reply. Lord, Lord. Just to not-
For your lordship's convenience, he said he'll come with some bullet points. It's been a long time. My submissions are also in form of bullet points. Just page numbers, etc. for your lordship's convenience. If your lordship permits, I can give it a copy to him to show that nothing extra has been there.
You have already given, Mr.
No, I've just now given the bullet
No,
points.
Mr. Chakraborty, yours. No.
May I
No,
present-
he's not given. He said he'll come with bullet points. So I have also given, just it's a long gap. That's why. Huh? No, consider.
Lord, I believe what was not argued, not that is there. Not,
It is.
I
I am
will
saying
counter, not whatever is argued by Mr. Bose.
nothing extra.
Mr.
Lord-
Bose,
No,
allow him, please.
yes.
Yes.
Now, Lord, my submission before your lordship was not only on mainly on 3
Mr.
points.
Chakraborty, speak clearly.
Is my submission before your lordship not was mainly on 3 points. Not
Yes.
first is not that, not the termination, which is I have challenged not 2 orders before your lordship. Not one is an order of termination of the contract, and the other one is banning.
Take your seat. Yes.
Now, my lord, with regard to the termination, Lord, Mr. Bose, my lord, has said that the 19th August order is the termination. And with regard to my submission was that, not apropos to that, my submission was that it has been passed without giving me any right of hearing, opportunity of hearing. This was my first submission. With regard to the termination, Lord, I submitted that they have invoked a wrong clause, which is the clause of cancellation. Invoking that, they terminated me. Number 3.
Clause 10 or something?
Yes, clause 10 they invoked. The termination clause is clause 10.1, but they invoked 10A and B, which is cancellation.
Yes.
Now, my lord, why they have invoked terminated me? Because the effect of termination is banning. So since I am terminated, they have banned me, but they have banned me for 3 years, where the tender clauses will not impose.
Didn't the clause say minimum of 1 year or something?
Minimum of 1 year. Minimum of 1 year. But why they have terminated me for 3 years? There is no explanation, no ground given, no reason given. Why it has to be 3 years, not 2 years, not 1 year? It has to be minimum 1 year, but why it is 3 years, nothing is stated. Now, my lord, apropos to this, what Mr. Bose, my lord, has submitted, my lord, my lord, as
So
much as-
don't be distracted by his note. You make your submissions.
Yes, I'm not concluding. Lord, he said, Lord, initially that they have given us lands, number 1. Number 2, it did not perform. Number 3, final measurement was done. Number 4, show cause for termination was given. Number 5, I have suppressed several facts. Now, Lord, I'll counter one by one. Now, Lord, with regard to, Lord, the termination, a question not failed from your lordship, Lord, whether any right of hearing is given. He did not answer that. He said we have given him a show cause. So no answer came from ECL with regard to the
What
right.
does the clause provide?
Lord, the clause doesn't say or doesn't exclude the right of hearing. But the law is laid down by your lordship's court, Lord. The provision of natural justice has to be read into the statute. Unless the
What is the statute here?
read into the contract clauses, Lord, the law has laid down that it has to be read into.
So the clauses say that a show cause notice has to be given and you will give a reply.
Hearing has to be given. I have to be heard.
No, that the clause says that.
Lord, the provisions of natural justice says that I have to be heard.
I'm asking you,
No,
what does the clause say?
Clause doesn't even say that I need not be heard. Clause doesn't say that I have to be heard. Clause
Yes. Yes.
doesn't say that I have to be heard. So no right of hearing is given. No answer came from them. Why no right of hearing is given?
Yes.
Now, with regard to the quoting of wrong provision, Lord, your lordship asked Mr. Bose why cancellation provision, invoking the clauses of cancellation, termination is done. He said that, Lord, quote unquote, I'm saying, yes, we have terminated following the cancellation clause. Why a wrong clause is invoked? Under what provision of law they
But did Mr. Bose say that the wrong clause has been invoked?
He said that invoking clause 10 and A and B, we have terminated. But that is a wrong clause in terms of the clauses. That's a clause for cancellation, not for termination. He said that we have invoked this clause.
Yes.
No answer on that. Now, Lord, with regard to banning for 3 years, why not 1 year? There has been no answer by them. That for this ABCD reason, we have decided to ban him for 3 years, not for 1 year. Now, Lord, with regard to the land issue. Now, Lord,
what is the land issue?
Lord, he said that sufficient land was provided to us. We did not work at the identity stage, Lord. I will just give you, Lordship, Lord, one document.
You have already said that it was something was given to you on 22nd July or something.
Yes, my case is that Lord, 21 acres of land was given to me in the July, and 1st August, a target was fixed, 19th August termination. But with regard to his submission, that sufficient land was given much before that and I did not work. I just want to show your lordship only one thing. Lord, one document I just want to give your lordship. Yes, kindly have a note. I'll have a look at this one.
My lord, regarding this land issue, it is lordship said you need not, we have to stick to the termination and the blacklisting on the basis of documents.
No, if they do not speak on that, then Lord, I need not answer.
Are you protected by an interim order?
Lord, I am.
You
I
are
am protected by an interim order.
you finish your submissions quickly.
Yes. Lord, I will take only 2, 3, 4 minutes more.
Yes.
Now, Lord, kindly have a look at that document once.
Have you given him a copy? Yes. And Mr. Chakraborty, be comfortable and make your submissions. Don't get nervous.
No, not about Lord. But before your lordship, I'm
That he
always
makes people nervous.
Sorry? Before my lord, I'm always nervous to answer your.
Entire bar.
Lord, I'm
Bar
always.
library, bar association, everywhere.
Yes.
I'm always nervous before the court to answer the court's query. Lord, kindly bear with me for
Hurry
2
up and
minutes.
make your submissions.
Lord,
Yes.
kindly have a look at the document that I have handed over.
Yes.
Lord, kindly see the dates just once. Lord, my case from day one was that they did not give us land, so we could not work. Kindly have a look at the dates in this, the document that I have handed over. First, initial survey, June 16, then February 17, then 7th February 17, 15th February 17, 15th February 17,
So
then
what
again
is this?
20.
What is the point of this document?
Lord, what I am saying is that from 17 to 20, no land was given. And till date, we have been provided with only 87 acres of land.
No,
as-
but the last column says status of mining complete. What is all this?
Yes,
Complete.
complete is not the land that was given. We have completed these 4 portions. 4 parts we have
You
completed.
have completed the mining.
Yes, the excavation, but the land was given in installments. We have done the work as much as the land is given. Now, with regard to the 5th installment, it's partly completed, and with the 6th, the work was in progress. Then, my lord, this termination order came. Now, what happened in the entire this period? Now, they have only given us 87 acres of land, as said by Mr. Bose. My lord, I don't dispute that quantum. But amongst that 87, 21 acres was given in July 2022. So from 16 till 22, 6 years, they could provide only, my lord, 66 acres of land.
So you have not included the July 2022 in this
Yes,
table?
yes, it is included. No, it is not included.
included.
70.55, not included. After that, they give. Lord, this is up to 2021. The date is June 2021.
Yes.
So up to June 2021, 70 acres of land we received. Lord, the query, the entire colliery is in 2 parts, query 1, query 2. Lord, query 1 is, Lord, having an area of 92 acres. Amongst that 92 acres, they were supposed to give their land in first 3 years. They did not provide that land. They provided only 70 acres from 16 to 21, 5 years. 22, they provided 21 acres. So, Lord, if the lands are not provided, how could the tenderer excavate? They are saying that we did not perform. So that, Lord, that they were at fault.
Who has prepared this chart?
Lord, we have prepared this chart according to the land given to us. And this is from the, we have copied this from the, Lord, survey map. From the survey map, we have copied this chart. This is one. Now, my lord,
So you have completed the mining pursuant to the surveys undertaken. There was nothing else to be done. It says date of survey, area surveyed, and then you completed the mining.
date of survey is
Yes.
not when the land is given.
Yes.
And the status of mining is that we have completed that portion of mining as on date. Now, my lord, what I'm trying to impress upon
And what
lords-
is first initial, 6th initial? What is all
Lord,
this?
CMPDI, they make the survey and the land is given to us. Lord, the entire area of the colliery is around 400 acres. Query 1, query 2. Query 2, they could not even give us any land. Query 1 is of 92 acres. They provided us 92 acres in 2022. But from 16 to 2021, only 70 acres.
What is this initial? What is this?
Not the first survey in 16, first initial, second initial survey, then third initial survey. They make a survey. They
So you completed the mining pursuant to initial surveys?
No. Initial survey, the land is given. The status as on date is that the mining is complete with regard to that portion of land. With regard to that one question of land.
My lord, with great respect, this is his self-styled chart which he has prepared. If he wants, I can give him the signed one, which is on 14/1/2023. What land was given to him and what land he can check. He is himself saying this much land is given and site. But the fact remains there is a letter, may not where is at in the writ petition with which we are concerned.
Yes, 21 acres of land given in July 2022.
No, it is incorrect. It is an incorrect
saying
statement.
incorrect? That's
You
a
have to-
document.
I have clarified that in my bullet
That's a
point.
document.
Yes, kindly see, my lord.
Kindly take
Watch
that
it.
page, my lord.
Very well. Mr. Chakraborty, I will
with
hear
regard to
Mr. Bose. You complete in 2 minutes now.
To the other points.
Mr.
Now,
Bose,
let's
you
go-
please don't interrupt me. Yes,
The
Mr.
first thing is
Chakraborty.
that the land is not provided to us.
Yes.
That is one of the reasons that the work got delayed. With regard to the query 2, the target is not 1 crore 18 lakh of coal. In Lord, a period of, that contract is a period of 13 years, 10 years, 3 years for query 1, 10 years for query 2. Query 2, the target is much higher, 1 crore 18 lakhs ton of coal and 999 lakhs of OB, overburden. So that land, 334 acre land has not been provided to us till date at all. With regard to query 1, the target 18 lakhs of coal and Lord in 3 years and Lord 68 lakh of OB, overburden. We have performed with the 70 acres of land that given, 8 lakh ton of coal we have excavated and 22 lakh ton of OB we have excavated. So that time to time the land is provided to us, we have worked. Lord, in all my representation, I have said that you please provide me land so that I could work. That has not been considered. Now, this is with regard to his third submission. Now, my lord, kindly take the other point that my lord, he has said, my lord, that I have suppressed facts. Now, my lord, to show that I have suppressed facts, he had, my lord, handed over one document to your lordships, my lord. Now, that is not a minute of a meeting. Kindly have a look at that document, my lord. The minute of a meeting, this document I am referring to, my lord, is flat.
এগুলো না সব ক্লিপ করে রাখবে, হ্যাঁ? Yes.
Now, my lord, showing this, he said that I have suppressed this. Now, my lord, kindly have a look at the date of the document, first page. In the middle of the page after the signature, today, 7th September 2022, meeting was conducted. My lord has kindly got it. My lord, if my lord looks into the impugned order, your lordship would find that, my lord, 7th September, they gave us a hearing with regard to the banning, blacklisting.
Yes.
So this is the minute of that blacklisting.
Yes.
So, my lord, it's not a case that I have suppressed that. That's a part of the impugned order, the order. Now, he said that I have admitted everything. Kindly allow me to read this, what I have admitted. He says, kindly, my lord, kindly read this. This is very, very interesting. First question, kindly see the question. Failure to achieve target. Then kindly see, we tried, my lord, this is all written by them. We have not written anything. All
So
written
you
by
were not present in this meeting?
I was present, but it is written by the officers. They asked
But,
me a
but
question.
these answers were not given by you.
Not my instruction, categorical instruction is these 3 lines have been inserted.
Inserted?
Inserted later on. I will show that it is inserted. With my limited understanding, I could get that. But I questioned them not at least 10 times that you are raising a very serious allegation. From one sentence, I will show that it is inserted. Why I say? But kindly allow me to read. Failure to achieve target. We tried but failed. Accepted the figure produced. Not this, according to my client, is not inserted. Then question number 2. Deployment of equipment as per 7C of NIT. And question number 3. Failure to install mobile tracer.
Chakraborty, if you raise this, I will ignore this document.
Yes.
I will ignore this document and go on the other documents.
What I am saying is that I have not suppressed anything. Kindly allow me to read the answer number 3. Then I
Why do you say it's inserted? And how do you make that out?
Yes, I'll just from the answer number 3. From the answer number 3. The answer is yes, failed. In future, we will install. Then kindly see the answer. Then again, answer starts with yes. The last answer. Yes, we accept failure on our part to provide required number of machineries as per the agreement, but this happened due to non-availability of sufficient land. Then kindly see the next sentence. But management did not fully agree. But if I give an answer, will I also write that the management did not agree? My answer was that yes, we accept failure to deploy machinery because we are not provided land. Last portion, the management did not agree, that they have written. Now, I am not inviting your lordship to go into any of them.
No, my lord, it's essential. Before he goes, no.
Why will I write?
No. To save his embarrassment, it's best that because his lawyer also signed, has said, you see the original, and then you make the submission. So no. You have made serious submissions.
Very good. But what I am instructed to say, I am saying that.
Instructed. Therefore, one should note whether this is how it is done. Now, which part has been because all signatures are at the top and at the bottom.
Yes.
Now, which part has been inserted?
So why will I answer that part of the management has agreed?
The same signature. So, which part? I have only made the Xerox copy.
They are handwriting. They written it.
They have written.
They have written it. Lord, to produce, by producing this, they tried to prejudice your lordship. That Lord, I have suppressed.
Now you see the.
Now,
yes.
He has raised
Mr. Chakraborty, your next point.
My lord. Now, Lord, suppression that I have accepted. Not what I have accepted is, yes, I could not deploy machinery because you did not produce me land. That was the only thing. Now, he has not made further submissions showing clauses 21, 23, 33, 39 at page 84 of the petition. Can you take that?
Yes. Just tell me your point, please.
Yes. Lord, Mr. Bose submitted that, Lord, that
Mainly he relied on 33 and 39 that I did not deploy skilled drivers, clause 33 at page 85, and page 86, clause 39, that not my trucks did not ply on the specified route. So they asked me a question of theft of coal, and I have admitted that. That was his submission.
Yes.
Now, my lord, I say with greatest of respect, none of this were a ground of termination. And he is trying to improve his case at the stage of, my lord, argument by, my lord, making submissions. My lord, apropos this, I rely on this judgment, my lord, following MS Gill, 2016, one Supreme Court cases, page 724. That
How has he improved his case?
Lord, he is saying that I have suppressed facts that I have been involved in, Lord, tip-top coal. I have admitted that I have not given land or not worked. That is not a ground for termination. Lord, the impugned order has to be judged on the ground that is written there. I'll have a look at para 4. These submissions are not coming from the bar, not in the impugned order. I'll look at para 4.
Yes.
There can be no gainsaying that every decision of an administrative or executive nature must be a composite and self-sustaining one, in that it decision contain all the reasons which prevailed on the official taking the decision to arrive at this conclusion. It is beyond cavil that any authority can be permitted to travel beyond the stand adopted and expressed by it in the impugned action.
Very well.
So, Lord, whatever is there in the impugned order, your lordship will judge the order on the basis of that, not from what is being handed over to your lordship. Kindly now, vis-a-vis this, apropos to this, take page 19, Lord, page 107.
But you don't think that page 107 is has the reasons?
Kindly take the reasons.
Yes.
Last paragraph.
Yes.
You were given 15 days time to explain your case. You no reply came. So your contract should be terminated. Clause 10 AB. So not on theft of coal, not on admission, not on anything else. Lord, he said, I have suppressed all facts. So if that suppression is material, which would alter the merit of the case, I can understand. That is Justice Rumapal's judgment. I rely on that. So the reason given is 10A and B. 10A and B is a clause for cancellation. He has to answer whether invoking a clause for cancellation, termination is permitted or not. Not, Lord, to show other documents, to impress upon your lordship that on the other ground it is terminated. Those are not the ground. So that is why I referred this judgment 2016 following MS Gill, this is rendered. So, Lord, whatever is reason, whether 10AB permits them to terminate a tender. That's my first. And Lord, only one thing, he said that final measurement. Since the final measurement is done, so Lord, I cannot come to
Mr. Chakraborty, I've understood. You better produce your points on the next day, and that will be the end of the matter.
And Lord, on the suppression of facts, my Lord may have this judgment, Lord.
What judgment?
Lord, which fact is, Lord, material fact, and what is the effect of that? If I suppress a material fact, what is the effect of that? That's Justice Rumapal's judgment, 2004 7 SCC 166. To counter his allegation that I have suppressed.
Produce it. Yes.
And Lord, I said again and again, I'm saying I'm ready to work. If they will not give me an opportunity, I can produce coal, I can perform.
Which paragraph?
Not paragraph, not 13. And that minute was referred to the impugned order. So I had no occasion to suppress that. And kindly appreciate not this.
I thought this judgment would go against you, no?
No, this is not a material fact. It would have been a material fact if on this ground they have not rejected my or terminated me.
Because it's usually cited by a party who says that suppression, therefore dismissal of the plaintiff.
Kindly not allow me to place.
No, that's fine.
It says that a material fact, all facts need not be disclosed.
Yes.
Lord, 7th September, there was a meeting.
Yes.
I could have understood that on the basis of that, Lord, my admission, what Mr. Bose said, if I even agree with him, yes, I admitted. On the basis of that admission, if the termination had happened, I had no case. You terminate me on a wrong clause. You terminate me without giving any hearing. You don't answer that. And you produce all lots of documents saying that I have suppressed. So, main points have not been answered. With regard to land only, I have handed over and I'm
Very
carrying that CMPDI, my lord, survey map.
Yes,
He
yes,
said
that
I am
is fine.
suppressing.
Thank you, Mr. Chakraborty.
These are my submissions, my lord.
My lord, may I give 2 minutes answer?
And with regard to, my lord, that interim order, when I placed the matter for, my lord, at the ad interim stage, lord, they gave an undertaking that they will not proceed with the new tender. So if today your lordship will not set aside the order of termination and the banning, from tomorrow I am ready to start the work.
Very well.
My lord, I gave the undertaking till 9th January. It's recorded, but unfortunately, the second portion, it continued. My lord, just exactly by the clock, 2 minutes of the factual things. My lord, letter show cause notice to blacklisting is at page 110. It records, my lord, that also violation of clause 33 and 39.
Yes.
That, my lord, your lordship will find in 111 clause 5. That is removal of this at my lord, I'm sorry, at 109. My lord, it is at 108 at 109.
Yes.
You will find, my lord, specifically mentioned in clause V that you are violating 33 and 39, which is basically the removal and of coal. 1. Now, termination letter, which is 19th August, my lord, at
33 and 39 are which pages?
I have given in your note in that in page, but immediately if your lordship wants.
Page 84, 85.
Yes,
85.
I have given your
84 and 85. Very well.
Yes, my lord, I have given
Yes.
that. Now, my lord.
Yes.
Now, my lord, the termination letter, which is of 19th August, my lord, clause.
That's at page 107.
107, the third line, again refers to 33 and 39.
You did not terminate me on that ground.
But he is right in saying that in the show cause notice, which I gave, 33 and 39 was not mentioned. Show cause notice referred only to not performance, may not. But 33 and 39 were mentioned in that ground itself. In the show cause, maybe it was not mentioned. Where is the show cause?
This only records.
Yes.
Why do you misguide him?
Oh, my lord, I am sorry. Even he is right.
My
lord, kindly see the third line. My lord, again after conducting preliminary.
Which page are you referring to?
My lord, page 107. My lord, kindly see the page, my lord, 107, third line.
Yes, I've seen that.
After
33 and 39.
conducting preliminary into the incidents, a show cause notice was issued in violation and which is dated 23rd
stating the
violation of
NIT
33 and 39, and the show cause notice is dated 23rd April 2022, which he has suppressed. Now, my lord, and there was no reply to this. So it is incorrect that both blacklisting, both this termination, it was done on that basis. But 10A and 10B, my lord, which is there, it is on top of his performance. This is one. Second, my lord, the land issue, which is going about, kindly see, my lord, the letter at 104, which is annexed to the writ petition.
37
Yes. Okay. My lord, kindly see what we have said in this letter. We have said that in the second line, he was complaining we do not have enough land. We have said there is enough land of 21.47 acres is available for your machine deployment. For your machine deployment. He was saying he did, and I have annexed a chart at 105. At 105, my lord. He is saying as if for the first time I am giving all this. It is incorrect interpretation. And it says in 105 that, my lord, kindly see that in the last working site, the total area in which you were supposed to work was 19.68 and 16.92 was available. And prior to that, you were working only in where you worked 5.62 there, and 4.55 was available. May not 4.55 and 16.92 is coming to 21.47. We say that where you are going with your machine there, land is available. My lord, and I've shown you a clause where it has to be done in phased manner. My lord, the clause in the bullet point I've given, it has to be done in phased manner. This land dispute which is creating, my lord, is absolutely incorrect. He has accepted termination by my lord Arkichu. I've given you this chart. How
Yes,
much
yes, that's
land?
on. Yes,
No answer on the right of hearing. They did not give me a hearing, there is no answer. Whether they not heard me before terminating, there is no answer. It's absolutely.
And my lord, he can check this inspection.
I have seen that. Yes, a learned counsel appearing for the petitioner has made his submissions. Stop. Learned counsel appearing for the respondent ECL has also clarified some factual issues raised by the court. Stop. List this, Mr. Chakraborty, when will you give your points?
Monday.
List this matter on
or whenever it comes to your lordships, or whenever.
19th April 2023 for the petitioner to give his points. Stop. এগুলো না সব লুজ কাগজগুলো একটা পিন করে রাখো। Yes, call on the next matter, please.
Item number 13.
I appear for the petitioner.
My lord, I appear for the state.
Lordship, may I file the affidavit of service?
Microphone, please.
Lord, the writ petition is, my lord, for inaction on the part of the district magistrate. Lord, we are the secured creditor. The borrower had applied for loan. Lord, thereafter he defaulted and the account was turned to NPA.
I can't hear you. Microphone, please. Yes.
Lord, the borrower had applied for loan. Lord, thereafter he defaulted and the account became NPA. Lord, we thereafter initiate the
Very well. Since when is the application pending?
Since 2018, Lordship.
Where application under section 14?
Under section 14 of the Surface Act, 1/11/2018, the application was filed. Well, that is at page. Lordship. Possession notice at page 93 and the application is at page 92, P7. Application and the affidavit is P7. Thereafter, my lord, the DM has not.
Where do I get the date from?
Lordship will kindly take the receiving date at the left hand side, 1/11/2018, at page 92.
Yes, what do
My
you
lord,
say?
the document which we have required, my lord, the document shows the property has been in some other's name. Lordship may kindly have a look.
Property has been in some
other person's name, some Kormokar, not of the private respondents. Lordship may kindly have a look to the report of the DM, my lord. 2 pages. I will show it to your lordship.
The property is not in the name of the borrower.
No, right now. It has been in some other person's.
So what, have you communicated that to the bank?
Yes.
When?
That I have communicated.
Okay.
Lordship, it has been communicated on 18th April 2019.
Lord, the communication was made on 25/5/2022. Thereafter, we have replied on 28/6/2022.
Several communications has been made, my lord.
We have already replied to that. The mutation certificate is also on record.
My lord, there is some, my lord, until and unless we get the proper document, my lord, we cannot initiate the proceeding. This is the difficult.
Document as to what?
Document, my lord, the lordship may kindly have a look to page 4 once of the report.
Yes.
This is the first communication. My lord, this has been made by the Block Land and Land Reforms Officer to the District Magistrate. My lord, first, second, third paragraph, my lord.
as per computer ROR record of right. These are the names of Radha Surakia, the name of the private respondent, has not recorded land over the Hali plot number so and so of above mentioned Mouja and LR Khutian number so and so of the above
What is it?
mentioned
Have you
Mouja
handed over a copy to your learned friend?
Lordship, I can give
No,
the
these letters were already replied to. In 28/6/2002, 22 bank had replied.
Yes, show me the last letter, please.
Those annexures, my lord, are not there. My lord, we have already replied to them. My lord,
Saying what?
saying that, my lord, whatever documents we have already submitted with the district magistrate. My lord, these letter that they are talking about is one person claiming to be a tenant there. They are claiming that we are there as a godown is there. My lord, that we have replied to, and the letter that my learned friend is speaking about is a mutation certificate. That mutation certificate.
Very well. Produce those
Lordship.
correspondence, please.
I-
Yes, the complaint of the petitioner, SBI, is that an application made by the petitioner to the concerned district magistrate, Bankura, under section 14 of the SRPC Act 2002, is pending since 1st November 2018. Stop. Next, the defense of the defense as put forward by learned counsel appearing for the state is that the district magistrate is that the document present is that the property presently is standing in the name of somebody else who is not the borrower. Stop. Council hands up a bunch of documents to prove to corroborate this point. Stop. Next, it appears to be an admitted fact that several letters have been exchanged between the petitioner and the district magistrate since 2018, which are not on record. Stop. The petitioner is hence directed to bring these documents on record by way of a supplementary affidavit, which shall be filed within.
Lordship, 10 days or 7 days, Lordship.
Within 10 days as prayed for. Stop. List this matter on 8th May 2023. Stop. A copy of the supplementary affidavit shall be made available to the respondents by 4th May 2023.
I'm grateful, Lordship.
Grateful, my lord.
Next.
Item number 14.
I beg to appear for Union of India. On the last occasion, it was heard extensively by your lordship, and your lordship was pleased to direct me to file one bullet points, some points with.
May I file my bullet points? For this.
What is this matter about?
Milord, this matter relates to Milord upgrade.
I can't hear you.
Milord, this matter relates to Milord technology upgradation scheme, Milord. Under the scheme, Milord, if I obtained loan from a bank, Milord, scheduled bank as incorporated in the scheme, and Milord, I utilize that fund for purchasing machine as mentioned in the scheme for expansion or exit for creating new unit, Milord, then if I then pay interest to the bank, I will get a 5% interest reimbursement, Milord. I have applied, Milord. My loan was sanctioned on, Milord, if I may just show your lordship, Milord, first the scheme, Milord.
No. Just your notes. That's
Yes.
all.
The scheme, Milord, as notes, Milord, there are two clauses, Milord. There is a cut-off date, Milord. Cut-off date is 1/4/2013. The loan has to be sanctioned after that. There is a clause, Milord, that is the clause, Milord, 3.5, which
You are
is
appearing for which respondent?
I'm appearing for the Union of India, my lord.
Union of India.
Milord.
And you are supposed to be granting that scheme, that
Yes.
subsidy
Yes,
to the
ma'am.
petitioner. Yes.
And now they have recalled that subsidy, Milord, without giving me an opportunity to refute, Milord, the allegation they have made. On that ground, that writ petition was filed. In the affidavit, Milord, they come up with a joint inspection report. Now, Milord, the two clauses are very.
Very well. Let me see the notes and I will, you can come back. Yes, learned counsel appearing for the parties have filed their respective short points. Stop. Yes, when do you want to come back, Mr. Tiwari and Mr.
As your lordship, please, my lord, only one thing, my lord, on 17th, the interim order will expire.
On 17th?
17th of April, Monday, my lord will kindly extend that.
Yes, stop list this matter. Council submits that the interim order is due to expire on 17th April 2023. Stop list this matter on that date. Stop.
My lord, may I pray for one indulgence, my lord? On
Yes.
17, I have some matter fixed. Can it be taken up on the second half, my lord?
Second half. If it is taken up in the first half, ask somebody to mention. I will put it in the second half. Next.
Well, great.
Item number 15.
I'm for the I'm happy. First of February 2023, my lord, this matter was heard by your lords.
Yes.
This matter was heard by your lordship, my lord. I made my submission. After conclusion of my submission, my lord, my learned friend started to make his submission, but my lord was not satisfied with his submission. That is why matter was adjourned, my lord. So kindly have a look to the order dated 1st of February 2023. Thereafter, interim order was extended once. 1st of February 2023.
Rule 22
Yes. Yes, my lord. Rule
of
22,
2004 rules.
He was
Yes, my lord. Kindly see the rule 22, my lord.
Can't hear you.
Kindly see rule 22 for a moment. Restriction on construction over tank and water board. A Gram Panchayat shall not.
Which page are you referring to?
My lord, page 10 of my rules, the West Bengal Panchayat Gram.
So say that.
Administration rules 2004. my lord.
Yes.
A Gram Panchayat shall not give permission to any erection or construction by filling up any tank, pond, or other water body, marshland, or abundant brick field or sand quarry, coal mine, mineral quarry, or any other water area. Your lordship's query was sluice will come under which heading, my lord? Your lordship's query was sluice will come under which heading, my lord? It will come.
What was the query?
Your lordship's query was sluice will come under which heading? Any
Sluice.
other
What is sluice?
Sluice means, my lord, it is a line of water supply, my lord. Any other river water, my lord. It will come under any other water area, my lord.
Yes.
And now your lordship kindly come to my affidavit in opposition, my lord. Yes, my lord, at page 11, start from page 12, my lord, where a number of, my lord, local residents had made a complaint before the PWD authority, my lord.
Yes.
Kindly see, আমরা নিম্ন স্বাক্ষরকারী আপনার দপ্তরের অধীন 10 নম্বর পলাশপাই অঞ্চলের স্থায়ী অধিবাসী হইতেছি। আপনার দপ্তরের সন্নিকটে পলাশপাই খাল হইতে জল নিকাশির জন্য আজুরিয়া পিডব্লিউডি বাঁধের উপর বহুকাল যাবৎ একটি স্লুইস গেট রইয়াছে। উক্ত গেট দিয়ে গ্রীষ্মকাল আজুরিয়া, যোধকেশর, পলাশপাই, জয়রাম চক এই সমস্ত মৌজাগুলোতে কৃষকরা চাষের জন্য জল ব্যবহার করেন এবং দীর্ঘ এলাকা চাষাবাদ হয়। এছাড়াও বর্ষাকালে ওই খালে সেচ দপ্তর ছাড়া জলে বন্যার ভয়াবহ রূপ দেখা দিলে উক্ত স্লুইস গেট মেরামত করবার প্রয়োজন পড়ে এবং অধিক বৃষ্টিপাতের ফলে এই সমস্ত মৌজাগুলো অতিরিক্ত জল ওই
What is the prayer in the writ petition? What is the prayer?
I have challenged the annexure, last annexure, page 81. I prayed for my lord's quashing of that impugned notice, page 81, by which my construction has been stopped.
And my lord, another thing, my lord, kindly, if your lordship see the porcha along with the sanctionment of the land is.
No, what is the effect of the impugned notice? What does it ask you to do or restrain you from doing?
My case is that I was making construction over my own land.
I purchased the property in 2016. My name was recorded in the land department. Thereafter, I applied for my lord sanction plan before the concerned local panchayat. My plan was sanctioned in 2018. I started to commence the construction work in 2018 for the in respect of the ground floor. Suddenly, I received a notice from the irrigation department that there is a land of the irrigation department. You are encroaching the land. Immediately, I replied. Thereafter, I made an application under the provision of Right to Information Act to seek information whether my land belong to the irrigation department or not. They
Yes.
specifically replied, no, this land belong to you. I have annexed all the documents. Thereafter, I have made application before the local panchayat for the purpose of construction of first floor. The local panchayat expressly by writing in my permission form, they have given me the permission. Yes, leaving aside 8 feet space, you can continue the construction work. In accordance with that sanction plan, I have started to make the construction work. Then only this notice was served upon me by them. This last page 81, I have been asked to immediately to remove the construction. I was making the construction upon my own land, but they served this notice. That is under challenge before your lordship.
Very well.
Malad,
Yes.
kindly see the picture.
Come back at 2 or some other day. What is this?
Malad, you'll-
What is this? Who is?
It will create obstruction, Malad, picture.
Yes.
And apart from this, Malad, one thing, another thing, Malad, that is.
Come back at 2 or some other day.
Fix another day, Malad. No, only difficulty 70 this Malad, my entry mode is going to expire, Malad.
Yes. List this matter on 17th April 2023 for hearing learned counsel, and also in view of the fact that the interim order is due to expire on that date.
17th, some certain difficulties. 17th and 18th, I have certain difficulties, my lord.
17th, 18th.
17th and
So
18th.
saying your interim order is expiring, what certain difficulty?
If your lordship kindly extend the interim and fix any after 18th, any
Very
day.
well. 20th.
My lord.
20th.
20th, I have some difficult 19th, Malad, 19th.
List is shop কেটে দাও যা বললাম. List this matter on 19th April 2023 as prayed for.
For the interim order, my lord, kindly extend the interim.
No, it will be extended only on 19th. Next.
My lord, kindly extend.
No,
the-
no, no, no.
Then my lord, keep it on 17th. I'll do the matter.
The interim order, which is due to expire on 17th, is extended till 28th April, till 30th April 2023. Yes, call on the next matter, please.
Item number 16.
No one appears for the.
Lordship, I am for the petitioner. Lordship, Advocate Sufi Kamal, who is appearing for this matter. he
I
has
can't
not
hear
come
you. What?
today. Lordship, Advocate Sufi Kamal, who is appearing for this matter. He has not come today. Kindly not today.
This is the second time that the petitioner has not appeared / sought for an adjournment. Stop. List this matter on 17th April 2023 as a last opportunity. Next one.
Item number 17.
I appear for the respondent number 5, my lord. My lord, we have filed our affidavit in opposition, my lord. Twice they have taken time to file their reply, my lord. They have not filed, my lord. This is the third writ petition on self-same cause of action, my lord. One has been dismissed for default and one has been withdrawn unconditionally, my lord. They have again.
No one appears for the petitioner. Stop. It appears from the orders that the petitioner has taken several adjournments, learned counsel appearing for the petitioner has taken several adjournments and had also prayed for a second extension to file the affidavit in reply, which was granted. Stop. The reply was to be filed by 3rd March. The reply was to be filed by 27th March 2023. Stop. The learned counsel appearing for the respondent submits that the petitioner has not filed any reply till date. Stop. List this matter on 17th April 2023 as a last chance to the petitioner.
Two PM fixed matter, item number 4.
I beg to appear for the petitioner, my lord.
I appear for the respondent number 1.
I appear for the respondent number 3.
Yes.
Lord, ESI Hospital Joka invited a tender in February for supply of cooked diet to the indoor patients. My lord, we participated in the tender process. On 4th of April, my lord, of 2023, the technical evaluation was completed and the petitioner was intimated that they have technically qualified.
Yes.
The tender my lord, on 6th of April 23, it was intimated that after technical evaluation, the bid number 3140298, that is the tender number also, 3140298, is moved to financial bid evaluation.
Whose bid is this? Yours?
But all the bids, all the technically qualified, 5 persons had participated, 4 were held to be technically qualified.
Oh, so 3140298 is what?
The tender in which we have participated.
Yes.
And out of 5, 4 persons were technically qualified. And I believe everyone was intimated on 6th of April that it is now moving to the financial bid stage. On 6th April itself, my lord, we receive another, my lord, I'll take your lordship through that letter first. 103, kindly take.
Just give me the facts, please, first.
Yes. My lord, on 6th April itself, my lord, we receive another email which does not refer to this tender number at all, that is 3140298. Nowhere. It does not refer to ESI Hospital Joka. And it says that a reverse auction is being held. Now, my lord, we receive these emails through a GEM portal of the government. Now, my lord, through the GEM.
That is for the procurement of
Yes.
supplies. Yes.
Yes, procurements and supplies, my lord. Now, my lord, through this GEM portal, my lord, we receive several emails where, my lord, we may have participated, we may not have participated.
Yes.
My lord, on 6th April, we receive an email which refers to a different number. I'll demonstrate it to your lordship, which says that up to 10th April, a reverse auction will be held.
What is unique about this number? This
Well,
3140298.
But these are tender number. These are tender number, my lord. The tender number is GEM/23/B/3140298. Why I am stressing on that? Because when I show documents after this financial bid stage, these numbers will change. And I'll take the point that how am I supposed to know that it is my bid that is going into the financial reverse auction? Because it does not give any details. I am completely in the dark. Now, my lord, after this, on 11th of April, I come to know that the financial bid, that the reverse auction has already taken place. And in the reverse auction where I have not participated, in the reverse auction of which I have no notice of, I am shown as L3, and beside my name, a price of 5 crores 20 lakhs has been mentioned. When the admitted case probably of the respondent is that I have not participated in the bid. And my lord, I'll also demonstrate
participated in the reverse auction.
Reverse auction in the financial bid. Now, my lord, I'll demonstrate from other documents that my bid, my original bid, before the reverse auction, which I have put in the tender, was much less an amount. It was about 4 crores 91 lakhs. Assuming that they have taken the base that I have quoted, from which the reverse auction backward would have started, that also is wrong. That also is wrong. They have assigning a random figure of 5 crores 20 lakhs to me, making me L3 without any knowledge of mine, without any participation of mine. And suddenly someone else, the existing contractor, becomes the L1 bidder by a very narrow margin. By very narrow margin becomes L1 bidder. And I am put in a position that heads I lose and tails they win, because today my remedy before lottery to seek for an interim order that no work order should be given. And that is the exact ideal situation for this private respondent number 3, because the moment it is stayed, they are the existing contractor, they again start running for a perpetuity. This is the exact situation they want to do. They want to create a situation where there no rules is followed and they do not care at all whether anyone challenges it or not.
You are L3, private respondent is L1.
Private respondent number 3 is L1, private respondent number 4 is L2.
Yes.
and their bids are quite close. Now, my lord, if I may take your lordship through the documents, kindly takes page 103.
What is the tender for?
My lord, the tender is for, my lord, providing cooked diet in a 400 unit, my lord, hospital to the indoor patients. Well, at page 103, your lordships will find
Yes.
that it is intimated to us that this is to inform you that bid number GEM 2023 B31400298, this is the tender number, has now moved to the financial bid evaluation stage on government e-marketplace, that is the full form of GEM, on 6th of April 2023 at 3:37 p.m. Thereafter, your lordships will kindly take page 104.
This is ESI, so this would be the central government or the state government?
Central government, my lord.
Yes.
Now, my lord, kindly takes page 104.
Yes.
It says that you are invited to participate in a reverse auction RA for so and so, so and so, so and so. Key aspect of RA are as follows. RA number, kindly marks this, my lord, GEM 2023 R 189254.
Yes.
The number changes. RA start date 6th April
So
2023.
this is now your number, 189.
But I do not know. There's no reference to my tender number. There is, your lordships will not find any reference to ESI Hospital Joka. No one knows what this is.
Yes.
Then, my lord, the RA end date is 10th of April 2023 at 3 p.m. And kindly reads with this another document, again by them only. Kindly, my lord, takes 106. And kindly, my lord, at the cost of inconvenience, my lord, kindly read 104 and 106 together. Same RA details at 106.
Yes.
RA details GEM 2023 R 189254.
Yes.
And the end date here, RA status active, RA validity 180 days, RA end date, your lordships will find in the middle column, second row, is 11th of April 2023. Same number. RA number is same, 189254. Once they say the last date is 10th April, once they say the last date is 11th April, they do not quote the tender number anywhere. They do not mention ESI Hospital Joka anywhere. And the bidder is supposed to know everything and participate.
And the number matches.
At page 104.
Yes.
It does not match with the main tender, but assuming this is a part of the main tender, they have suddenly given a new number, re-questioned it. 104 says the last date of reverse auction is 10th April. 106 says last date is 11th April. So assuming I had knowledge and I would have wanted to participate, I would not have known when to participate. One is 10th April, one is 11th April.
That is the end date.
That's the end date.
Starting date is the same.
Starting date is the same.
Yes.
Thereafter, kindly take page 105.
Yes.
RA details 189254.
Yes.
There, my lord, at L1 is R3, respondent number 3. L2 is respondent number 4. And I, the petitioner, I am at L3 and kindly marks my bid price. 5 crores 20 odd.
Yes.
And I have quoted your lordships will find my quotation at page 97. At the bottom, page 97 bottom. But at page 97, we have not supplied in the annexure the item-wise rates, for business purpose, because it will be open to the private respondents also, against which item we quoted what. We have only given the total.
So what is, I can't read. What is the figure?
At the bottom, at the bottom, just above the signature, your lordships will find 2 crores 45 lakhs 59,620. This is for 1 year.
Yes.
This is quotation for 1 year, and multiplied by 2, this figure will come to 4 crores 91 lakhs 19,241. We have treated and given the calculation at paragraph 4 for your lordship's convenience, my lord.
Yes.
So, my lord, assuming that that is the base price and I have not participated, so whatever I have quoted, that has gone down there because of my absence. Then also, my lord, 5 crores 20 is a absurd figure, my lord, which is being assigned to me.
No, what is this reverse auction?
My lord, reverse auction is the highest price
Yes.
on which, my lord, all the bidders participate and say that how much low they can go to carry out the work.
So they are asked to match it.
That matching has not come. That matching part has not come. The only part which has gone is that how much a bidder will go down to get the tender. Everyone has quoted some price.
So you have to match the lowest price.
If they give me an opportunity, my lord, I should and I would. And I am putting that on record.
I'm asking you as a general question. What is a reverse auction?
My lord, in the reverse auction, my lord.
Not the facts of this case.
Yes, yes. My lord, in the reverse auction, there is a higher price.
Yes.
My lord, for example, let's take, my lord, the higher price is 5 crores. The bidders are allowed to participate in the reverse auction where they do not go up, but they go down by saying that I agree to do the work for 4 crores 99 lakhs.
So 5 crores is fixed as a ceiling.
Is the ceiling. Then everyone says how much low they can go. So, like in this case, perhaps L1, the person who is L1, he has said that I can do the work for 4 crores 33 lakhs 24,000. And the L2 has said I'll do the work for 4 crores 33 lakhs 71,000. So they have gone that much low. But I say I never got this opportunity to come and say that how much low I can go to get this work. That chance was never given to me. And in the most clandestine manner, just to give it to the existing contractor, that is the respondent number 3, they have done it in this way. There is no reference to the tender number. The 2 notices say completely different dates altogether. When it is to start, when it to end, one says 10th April, one says 11th April. And assuming my base rate is also taken, that is also wrong. There is nothing to show for 5 lakhs 20.
Very good. Yes. Anything else, Mr.
So, my lord, this is my case. My lord, I'll request your lordship, my lord.
What is the relief you have asked for?
My lord, I seek, my lord, a evaluation from the reverse auction stage. Because
you want to participate.
I want to participate in the reverse auction and in the alternative.
What was the result in the technical stage?
But I qualified.
You qualified.
4 persons qualified. My lord, the names of 3 are reflected in 105. But my lord, alternatively, if your lordship kindly takes page 105.
Yes.
Towards the middle, they themselves have given a disclaimer. If your lordships are at page 105, my lord, the disclaimer says that these are offered prices in bid and not approved accepted prices. These may change if buyer resorts to the negotiation or price match as per bid conditions. So, my lord, they are entitled to negotiate. Even if they give me an offer to match the price, my lord, I am ready to match the price. I can do it for lesser price, in fact, and I can put it on record.
Lesser price than 5.
Then the L1. Then the L1.
L1 is 4.33.
4.33, yes. And my lord, if your lordship wants, my lord, I can give the figure right now, but not, my lord, only to your lordships, my lord. Only to your lordships.
Very good. Yes. Microphone.
Yes.
You're appearing for ESI.
Yes, my lord. Respondent number 1. First of all, my lord, yes. My lord, first of all, I'll say, my lord, that respondent number 1, being the ESI corporation, has got no role to play because everything, all this tender process, everything, lot bidding and everything is done through GEM, government e-marketplace, whatever.
Yes.
So lordship kindly says, Lord, it is the in this writ petition, if your lordship kindly takes each petition, paragraph 3, he had a knowledge of everything. Now, when everything had been completed, all the process had been completed of bidding and all that, he was, my lord, it is not that if your lordship kindly takes from my land.
Paragraph 3 says what?
Paragraph 3, lordship kindly says, the respondent number 1 hospital floated a tender being number JAME 2023 B 3140298 dated 16th February 2023 for catering the healthcare, kitchen and dietary services and general ward diet, full regular diet, soft diet, liquid diet, pediatric, diabetic,
Yes, just skip
all these
over
are
all
things, my lord. For 6 months, my lord, there was a my lord, time dinner for 400 units for the period 2 years from the grant of the work order, twice renewable for the period of 6 months each. Now, the bid submission for the said tender started on February 16, 2023 and ended on March 3, 2023 at 14 hours. The tender schedule provided in the bid document available in the government e-marketplace portal specifies the bid end date and time to be March 3, 2023 at 14 hours, and bid opening was scheduled for March 3, 2023, 14:30 hours. So, Lordship, everything he knows, he has quoted in his petition. Now, your Lordship kindly takes, my lord, paragraph 7.
No, but he says that he doesn't know about the reverse auction.
My lord, reverse
is-
auction on 6th, my lord, your Lordship kindly takes, my lord, 6. This was, he is annexing these, my lord, documents. 104, my Lordship kindly 6, my lord. 104. This is a, yes, Lordship, it is a, my lord, Thursday, April 6, 2023 at 3:44. He is getting reply is being given to the, my lord, the nodal officer of the GEM has given this, my lord, in reply to his letter, my lord, to quality caterer, the petitioner here in, my lord. He is getting, you are invited to participate in a reverse auction for healthcare, kitchen and dietary services, general ward, diet, full regular diet, soft diet, liquid D on government e-marketplace. Key aspects, my lord, these are the RA number was there. My lord, RA start date is there. My lord, 2004, 6, 2023, 15:44 hours, my lord. RA end date is there, my lord. So, Lordship kindly says, my lord, here everything, my lord, he is the, my lord, it was within his knowledge. Everything was within his knowledge. Now, how my learned friend can take, my lord, as a surprise, my lord, that I do not know anything, my lord. He has been qualified. He has qualified for that tender, my lord. He has participated. He has given his prize. He has, my lord, page. If your Lordship kindly takes, my lord, the page, my lord, this page 105.
But
we have taken care of his bid also.
104, the RA start date is 6th April 2023. Is that correct?
Paragraph, then, my lord, Lordship kindly takes to, my lord, paragraph 8.
I'm asking a question. Look at 104.
Yes, my lord.
The start date says 6th April 2023. 15:44.05.
It was still 6 to 10. Not only 6, it was completed. It was 6 to 10. It is his own averment, page 8, paragraph 8.
Come to
That's why.
106.
106. Yes, my lord, I am coming.
Says start date is 3rd March 2023.
Start, my lord, this
No,
one which
start date is 6th April
106, my lord.
Yes.
That was the original auction, my lord, which was held in the year, in the month of February 2016. First bid. He has not participated in the second
RA
bid.
opening date 3rd March. How can it be reverse auction opening date 3rd March 2023?
Yes, Lordship, can you
Page
say RA
106.
status, my lord, RA start date, my lord, 6/4/2023.
Come to the next, the third one. Can't you understand what the court is telling you? The third entry, the third entry, RA opening date 3rd March 2023, 2:30 hours. How can it be reverse auction?
RA opening date, my lord, that was opening date.
3rd March.
Here, this is, my lord, opening date of 3/3/2023. It was with regard to the first auction that was held in the February 2016.
So that couldn't have been a reverse auction.
My lord,
It says
later on,
RA
it was decided to go for a reverse auction, my lord, and for reverse auction also it was within his knowledge. So that's why, my lord, 107. My lord.
Your second point.
Yes, my lord, page. If your lordship can, it's a continuous process, my lord. Everything was within his knowledge. Now, when everything has been completed, now my land friend has come before your lordship. There was a transparency. There was everything was this bidding process. Everything was maintained.
Very well.
As per the law.
If I accept your position that he did not participate, then how can you give a point of 5.20 crores at page 105?
My lord, if your lordship kindly comes to, my lord, paragraph 8, my lord, of the writ petition.
Answer the court's question first.
Yes.
If you don't hear the court's question, it's your bad luck.
I'm sorry. I'm sorry for that.
Come to 105.
105.
If I were to accept your submission that the petitioner did not participate, then how did you quote this bid price in the reverse auction?
My lord, I am saying, my lord, I have first, my submission was that he was qualified for this bidding. He has participated in the process, bidding process. My lord, that's why, my lord, he has quoted his price. That's why, my lord, we have considered he was the highest one. And
you submitted to the court that he did not participate in the reverse auction.
he has not participated in the, my lord, Khadi. There was two tender for Khadi. Gram Udyog, that was another, and for kitchen and the diet purpose, there was another. That was, he has participated in first, my lord, on 2016.
What is 105 relating to?
105, my lord, his quality capital, my lord, item categories, healthcare, kitchen and dietary services. He has quoted his price, bid price.
So did he participate in the reverse auction or did he not?
He has participated in the bid. That's why, my lord, it has been quoted here.
But you told me in the morning that
in the morning, my lord, I have said, my lord, in the morning that, my lord, I have not received the brief. Only on the telephone, my lord, there was a telephone message, my lord, that I am coming. I have, my lord, Lordship kindly says he has given this writ petition today. What today? He has received.
Just answer the court's question.
Yes.
Has he participated in the reverse auction or not?
In the bid process, my lord. Yes. In the tender process.
In the reverse auction.
Reversed auction, my lord. My lord, there was a letter, my lord. 103, my lord, 103. That, my lord, he was aware of, my lord, that, my lord, Lordship, and this is to inform you that bid number such and such has
So
now
did he
moved to the
participate after that or not? Did he participate? Yes or no?
My lord, in the reverse, my lord, as it seems, my lord, that he has, my lord, in the reverse, my lord, auction, my lord, he has not participated.
He has not participated. That is what I'm telling you.
Yes.
That is what you told the court in the morning. So don't change your submissions like this.
I'm not changing, my lord.
Don't confuse the court. I told you 5 times that this is the submission you made in the morning that he did not. Then you're going on saying he participated.
Very well, my lord, very well. Page 34 then. Page 34, Lordship kindly says, my lord, who will participate in the reverse auction, my lord, page 34. My lord, page 34, Lordship, type of bid. My lord, before that, RA qualification of rule. Lordship kindly says, my lord, RA qualification. Page 34, my lord, from the top, my lord, I'm saying, my lord. Page 34.
What is 34?
Qualification of rule. That is, my lord.
What qualification of rule? What are you showing me? Where is the first page of this document?
And this is a bid document, my lord.
So say that, please.
Yes, it is a bid document, second page, page 34. Your Lordship kindly says, my lord, here type of bid. I'm sorry, my lord. No. Yes, that's a column 2, my lord.
Yes.
Lordship. RA qualification rule, that is H1 highest priced bid elimination. Lordship got it? Now, my lord, Lordship.
What is the point? What is your argument?
I am saying, my lord, then your lord, I will show, my lord, paragraph 8, next page. Your Lordship, if your Lordship will not go through the, my lord, the conditions of the bid.
Give me your point, then show me the document.
Yes, I am saying, my lord, he was not supposed to be participated in the reverse auction for the reason that he has been eliminated because the price which he has quoted, L1, L2 was taken into consideration. Their bid was because this tender process or this document says, my lord, it would be the third one highest that would be eliminated. That's why I'm showing this, my lord. If your Lordship kindly takes for RA qualification rule.
Then what about page 105?
I'm coming, my lord. Lordship kindly see, my lord. Kindly give me, my lord, to make my submission in my own way. That's why, my lord. Kindly, my lord. Page very next page, my lord. Page 35. Your Lordship kindly takes, my lord. Page 35. My lord, clause 8.
Yes.
Yes. My lord, reverse auction, my lord, here. Reverse auction would be conducted amongst all the technically qualified bidders, except the highest quoting bidder. Lordship kindly says, my lord, excepting the highest quoting bidder, the technically qualified highest quoting bidder will not be allowed to participate in RA. However, H1 will also be allowed to participate in RA in following cases. So these are not the cases. Yes, my lord. If a number of technically qualified bidders are only 2 or 3. Lordship, got it, my lord?
Very well. So you're saying that the petitioner was not qualified to participate?
No.
Then why did you send the mail to the petitioner?
Yes, my lord.
If the petitioner was not qualified to participate, then why did you send the mail to the petitioner that we invite you to participate?
Actually, Lordship kindly says, my lord, he was the petitioner was L3, my lord. Lowest, my lord, 3. So, my lord, there are
if the petitioner was technically disqualified, then come to page 104.
104, my lord. I'm coming, my lord.
That was your first submission. You're completely confused.
My lord, the lordship kindly says, my lord, he was technically qualified, but the lowest bidder was, my lord, we have taken into consideration the lowest, my lord, bidder. L1 and L2.
Just now you made a submission that the petitioner disqualified himself because he did not qualify the technical bid. Then why 104?
My lord kindly says, my lord, he was L3. So we have taken into consideration L1 and L2 because their price was much below than the petitioner. So L1 and L2 was taken into consideration.
Very well, but you showed me the mail that you asked the petitioner, you invited the petitioner to participate.
Yes, only for this region he was participated in the main bid process. For that region we have already has asked for, we have given the reply. It is normal course, in a normal course, my lord, when he has written a allotted, my lord.
Your next point.
Yes, my lord. This is the point, my lord, what I'm saying, my lord. He was technically qualified, my lord, but my lord, his bid was, whatever the price he has quoted, that was, my lord, highest to the two bidders, my lord. So that's why, my lord, we have taken it was L1, L3. L1 and L2 was taken into consideration in the, my lord, reverse auction.
Next point.
So, my lord, I am saying, my lord, I have said so that even, my lord, 6, he has got the letter on 6. So he could have, my lord, enhanced his bid or down his bid, whatever he got time, sufficient time to do that. Now, my lord, when entire process has been completed and there was a transparency, there was no, my lord, question of any malafidness or arbitration on the part of the chain. So, lordship kindly see, in my most respectful submission, when everything had been completed and there was it was within the knowledge of the petitioner, my lord.
So your submission is completely inconsistent and contradictory to one another. I'm telling you what your submissions are. Correct the court if I'm wrong.
Yes, my lord.
Number 1, the petitioner did not qualify in the technical bid. Number 2, because he did not qualify in the technical bid, he could not have participated in the reverse auction. Number 3, the petitioner did not participate in the reverse auction. That's number 3. That's your position in the morning as well as now. That the petitioner did not participate in the reverse auction.
In the morning, my lord, I took for time, my lord. My lord, your lordship is, my lord, could I have said so, my lord?
Very well. Is your submission that the petitioner participated or did not participate?
My lord, in so far reverse, my lord, auction, my lord, they have not participated, my lord. I'm saying.
Very well. So then why are you interrupting the court? No hanky-panky with this court. Try it with other courts.
My lord, what I have made fair submission before your lordship.
The petitioner did not participate
because
in the reverse.
In the morning, I didn't have the brief with me, and that's why I took.
Very well. What is your submission now? I'm giving you that chance.
Yes, my lord. That's why I'm saying, my lord, here everything, my lord, was within his knowledge. Did
he participate? Yes or no? In the reverse auction.
In the reverse auction, he did not participate.
Very well. That's your third submission.
Yes.
What is your fourth submission?
Fourth submission is this, my lord. We have taken into, as per the rule, as per the conditions of this, my lord, the tender process and tender documents, my lord, that we are supposed to take into consideration the L1 and L2, and that's why we have taken this, my lord.
Very well. Anything else?
So, my lord, in my most respectful submission, my lord, that this process, whatever, my lord, this bidding process, everything was done in a transparent manner.
Yes. Hurry up in 1 minute. Who are you for?
I'm for the
microphone.
Respondent number 3.
Microphone.
Who has the highest bidder, having lowest price, quoted lowest.
Do you know
price.
how to use a microphone or not? Microphone.
Yes, my lord, I'm using. And my lord, again, my lord, I'm repeating that page 3, my lord, that clause 8 of that page 35, my lord, kindly have a look into.
Yes.
My lord, I am in category L1. I'm the highest bidder having quoted lowest price. And the respondent number 4 is the L2 category. And
which page shows that you have quoted the lowest price? Which page?
Synopsis page in everywhere in the repetition.
Synopsis. Show me from the document, please.
Oh.
Show me from the document.
In 105.
Yes. Who are you out of these 3?
This Nihar Enterprise, my lord. L1.
Your respondent number?
Number 3. And my lord, respondent number 2 is Sonar Bangla.
Yes. You are representing both?
No. My lord, I'm stating about.
Yes.
It is L2 and L3 is the writ petitioner.
Yes.
And my lord, the rule says, my lord, highest bidder will be eliminated.
Yes.
And clause 8 says this reverse auction would be conducted amongst all the technical qualified bidders. He is technically qualified.
Very well. Anything
petitioner.
else?
And my lord, H1, however, H1 will also be allowed to participate, having highest bidder, giving highest price, my lord, RA following cases, my lord, 8 clause 8, 1.
Very well. Anything
Subclause
else?
1. Because 2 or 3 persons, if there will be 2 or 3 persons, then he will be eligible to participate. That is why they have given.
Which rule are you relying on?
My lord, the
Page
page
35,
35,
rule 8.
35, clause
Rule 8.
Clause 8. Clause 8, subclause 1.
And who is the highest quoting bidder who was not allowed to participate?
Highest quoting bidder is the writ petitioner, L3 category. Because 2 or 3 persons are there, my lord, it is
Yes.
coming under them. That is why they have given the notice. Authority has given the notice, my lord. Email or notice,
If
my
the
lord.
petitioner is the highest bidder
Yes.
and is disqualified under Rule 8,
Yes.
then the petitioner will not be able to participate. That's your case.
Yes.
Is that your case or not?
No. He is eligible under this clause. That is why the authority has given the notice. But he has not the opportunity, he has not upheld. My lord, for notice that, my lord, kindly have a look into 104, my lord, annexure P6, my lord. 6th April 23, my lord. Authority has
Rule
given-
8 says, come to Rule 8, please,
Yes, my
page 35. Rule 8 says that all the technically qualified bidders, except the highest quoting bidder,
Yes.
will be allowed to participate in the reverse auction. Does it say that or no?
Yes.
Yes?
Second
Very well. And says that the technically qualified, says the same thing, the technically qualified highest bidder will not be allowed to participate in the reverse auction. So first and second sentences, second one is superfluous, says the same thing.
Yes. Then, my lord,
In this
however-
case, please, in this case, who is the highest quoting bidder who is technically qualified, according to you, the petitioner? Hence, Rule 8 disqualifies the petitioner
No,
from
my lord,
participating.
the last portion did not disqualify him. My lord, however, each one will also allowed to the participate. H1 means highest bidder. Who is highest bidder? H1. That is allowed to participate in RA means reverse auction in following cases. Clause 1 applies to him. Here, my lord, 3 bidders have been qualified. That is why it is applied, and that is why authority has given the notice.
Very well. So your case is that the petitioner became eligible because of 8I,
Yes.
but chose not to participate. That is what you're saying.
No. He has chosen to participate, but he has not participated. He has not availed that opportunity.
What does this mean? Chosen to participate but not participated?
My lord, he has got the notice, but they have
Very well. Yes. Yes, Mr. Bond.
not in portal. That is why
Yes.
fairness.
My lord, two major submissions. Number one, if I was the highest bidder, I would have been disqualified and I would not get an opportunity to participate in reverse auction at all.
What about 8I?
Yes, I'm coming to that, my lord. And the second submission, my lord, is that I was given the opportunity, but I did not participate.
Yes.
Before coming to clause 8, I need to support one of my earlier submission with a document. Kindly takes page 102, because I had submitted that there were 5 bidders and there were 4 qualified bidders. At 102, your lordships will find there are 5 names mentioned on the left hand side as the seller name, and towards the middle there's a row which shows the status as qualified, 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 disqualified, qualified.
Yes.
So, my lord, there were 4 qualified bidders according to the portal. Clause 8, Rule 1
says if the technically qualified bidders are 2 or 3.
Yes, here it is 4. So 8 Roman 1 will not apply at all. Number 1.
Yes.
Number 2, if their submission is that I was the highest one, then I would have been disqualified. Page 106 or 104, whichever is true, I do not know, because the end date does not match in both. Whichever it is, I would not have received it because I was H1, I am disqualified. Yet I receive 104, which does not have any reference to the tender number, which your lordships will find at page, several pages, but I am referring to 2. page 32 to start with. 32 gives the specific bid number. Then, my lord, where I am stated to have qualified
Yes.
at page 101, which said that technical evaluation for GEM so and so B314028 dated so and so has been completed. Technical evaluation results so and so. It quotes a particular number. Then at 103, which says that this is to inform you that bid number GEM 20 so and so 314028 has now moved to the financial bid evaluation stage on the government e-marketplace so and so. Everywhere this number has been quoted, except when it comes to the reverse auction, the number is changed. There is no reference to this number, no reference to this bid, no reference to ESI Joka. And they expect us to know where we get bunches. In this portal, we get bunches of these same mails, same things about tenders. We don't even participate. It's a government portal. We don't need to participate to get these informations. It's like a buzzing Twitter account.
Mr. Bandyopadhyay, were you aware of this invitation or not to participate in the reverse auction?
Page 104, I was not aware.
Please stop nodding your heads. Take your seat, both of you. Yes.
Page 104, I was not aware. Because, my lord, page 104, whether it refers to my bid or not, it has no reference to that. I was not aware of it. I had not participated. That is my consistent case in the entire writ petition. And they are wrong. It lies in the fact that they have assigned a figure against my name, which doesn't even match with the, assuming my original figure was taken. My original figure is 4 crores 91. I have nothing to be proud of. It is still 60 lakhs more than what the L1 has quoted. But 5 crores 20 is not my figure. To show that there were 3 bidders and one person is completely vanished. There was another qualified bidder, Jana Enterprise, who has completely vanished. And my assumption is that, my lord.
Yes. Where are you getting that figure of
4 crores 91? Yes.
Yes.
My lord,
Which page?
I take page 97. But it is a bit illegible. If your lordships are pleased to kindly take, my lord, pleading at para 4 also.
Yes.
It corresponds to that same annexure, my lord. In view thereof, the petitioner number 1 submitted its bid of rupees 2 crores 45 lakhs 59,620 rupees so and so for 1 year, which tantamounts to rupees 4 crores 91 lakhs 19,241.8 for 2 years.
Yes.
No relation to this 5 crores 20. But this figure is being saddled upon me just to show me as the L3. But kindly gives me an opportunity to participate or match the lowest, my lord, because the clause is already there at page 105. It is their clause. They say that even this L1 is not final. No right has accrued in favor of the private respondent as yet. But disclaimer says at the cost of repetition, my lord, these are offered
Yes,
prices.
I've understood, please. Don't repeat.
My lord.
Yes. Option 1. The petitioner participates in the reverse auction, matches the price of 2 and 3. If that is not suitable to you, I will give a temporary stay until you file affidavits. That's option 2. And of course, I will dictate an order with reasons, but I'm giving you that option.
Milord, may I say, Milord?
Of course.
Milord, yes. I have been told, Milord, that in spite of having knowledge or getting opportunity.
No further arguments.
I'm not saying, Milord.
Just tell me which option you agree to. That's all.
Because, Milord, the respondent number 1 as such has got no role to play after Milord Jim. Because
that's a different matter.
Yes, that's
if
a
you have
gem.
no role to play, you're not bothered with what order I pass.
But
if you have no role to play.
My lord, role to play, Milord, because it is a gem. who is conducting all this tender process, everything.
I will pass the order. Then it is up to you how you carry out the order. That's all. I will pass. It is not my responsibility to see who is going to be affected. My responsibility is only to pass an order,
Yes.
but with reasons. That's all.
Yes.
So I'm giving you the option. Which one? I never do this. I'm just giving you the option.
My
Which
lord,
one
my
you
lord,
agree to?
I'm really grateful for your lord, grateful to your lordship, my lord. But my lord, lordship conditions, my lord, in my most respectful submission, my lord, the options your lordship has just put, my lord, my lord, I'm saying, my lord, my same submission would be, my lord, before your lordship, my lord, because, my lord, though the knowledge was there, he has not participated in the reverse auction. Now it is not, my lord, open, my lord.
If I'm going to stay any further steps being taken by you, if you are not agreeable to that, and I will record it in my order, obviously, then I think the lesser effect would be allowing the petitioner to participate in the reverse auction. Hold it afresh.
My lord, in this, my lord, I leave it to lordship, my lord. Whatever lordship thinks fit and proper, my lord, I leave it to lordship, my lord. But my lord, that my submission be kindly record, my lord, that
The petitioners participated in a bid floated by the capital G, small e, floated by the respondent numbers 1 and 2, who are the ESI Medical College and Hospital, Joka, Diamond Harbour Road, Kolkata. Stop. The bid was for supply of, where do I get that, Mr. Bandyopadhyay?
Your lordships will get that, my lord, at page.
Quickly.
Yes, my lord. Page 33.
For supply of
towards the middle.
Healthcare kitchen
and dietary service.
and
That
dietary
should be enough.
service. Stop. The bid document is dated 3/3/2023. Stop. The petitioner participated in the bid. Stop. The technical bid was completed sometime in April.
4th April.
Was completed on 4/4/2023. And the petitioner was communicated, and the petitioner received a letter on 6/4/2023 asking the technical bid was completed on 6/4/2023, and the petitioner was communicated with a document stating that 4 out of 5 bidders had qualified in the technical bid. Stop. The petitioner was thereafter, the petitioner thereafter received a mail on 6 April 2023 inviting the petitioner to participate in a reverse auction on the government e-marketplace, e-marketplace within brackets, capital G, small e, capital M, close brackets, for in connection with an RA number, which is different from the bid number given in all previous correspondence between the ESI hospital and the petitioners. Stop. Next, the petitioner's case, comma, as would appear from the submissions of learned counsel, comma, is that the petitioner could not, was unable to understand the implication of the mail of 6/4/2023, since the bid number reflected therein was had no connection with the bid number recorded in any of the letters exchanged between the parties, including in relation to the technical bid. Stop. The petitioner hence did not participate in the reverse auction, but was surprised to find, to receive, and hence was surprised to receive a mail of, what is the date of the document at 105?
Well, this is the 11th April, but we did not receive it by mail. We saw it in the portal. On 11th.
And was hence surprised to obtain the information from the official portal of the respondents on 11/4/2023 that the petitioner was assessed as L3 after quoting a price of rupees 5.20 crores. Stop. Next, the L1 and L2 are the private respondents and are represented today before the court, and are represented today. Stop. Next, learned counsel appearing for the respondent ESI hospital submits that the petitioners chose not to participate in the reverse auction despite being given an opportunity to do so. Stop. Counsel also submits that the petitioner, comma, being the highest bidder, comma, being the highest bidder in the technical bid, comma, was disqualified under clause 8 of the bid document. Stop. It is also the case of the of ESI hospitals that the petitioners chose to come to the court at a belated stage for seeking necessary orders. Stop. Next, learned counsel appearing for the L1 and L2 bidders / private respondents makes similar submissions to makes submissions which are similar in content to the ones made on behalf of the ESI hospitals. Stop. Counsel also relies on clause 8 to say that the petitioner number 1 was disqualified by reason of rule 8 choto I of the bid document. Stop. Next, the conduct of the respondents in the matter of the reverse auction is liable to be called to question at several levels, on several levels. Stop. First, comma, the admitted case, comma, even according to the respondents, comma, is that the petitioners failed to participate in the reverse auction despite being put to notice thereof. Stop. The other case of the respondents is that the petitioners, comma, despite being invited to participate in the reverse auction by the mail of 6/4/2023, comma, was however disqualified from participating by reason of rule 8. Stop. The third, clause 8, stop. The third case is that the petitioner despite being disqualified under clause 8, however, was eligible to participate in the reverse auction in view of clause 8 small I. Stop. All the three cases are mutually contradictory to each other and are inconsistent, mutually contradictory and inconsistent with each other. Stop. Next. Rule 8 of the tender document, of the bid document, indicates that the reverse auction would be conducted amongst all the technically qualified bidders except the highest quoting bidder. Stop. Rule 8, however, clause 8, clause 8, however, goes on to say that the H1 bidder will be allowed to participate in the reverse auction in certain cases which would arise if the number of technically qualified bidders are only 2 or 3, within brackets, clause 8, small I, close brackets. Stop. Next. Even if the self-contradictory cases made out by the respondents is taken to be correct, comma, the documents before the court show that 4 out of 5 bidders qualified in the technical stage. Stop. Hence, comma, clearly, comma, hence clearly, comma, rule 8 small I would not apply in the present case, since the technically qualified bidders were more than 2/3. Stop. Further, the upshot is that the petitioner, comma, as the highest, as the H1 bidder, comma, would not be technically qualified, would not be in a position to participate in the reverse auction in view of rule 8, clause 8. Stop. Next. This fact is, however, belied by the mail of 6/4/2023, by which the respondents invited the petitioner to participate in the reverse auction. Stop. Hence, comma, the respondents have gone against the very case attempted to be made by them before the court. Stop. Next. Fourth, comma, if the petitioners admittedly did not participate in the reverse auction, comma, the document which the petitioner, the portal of the respondents, which was made known to the, which the petitioners became aware of on 11/4/2023, shows the name of the, reflects the name of the petitioner, not only reflects the name of the petitioner, but accompanies the same with a bid price of 52047200.00, within brackets, rupees 5.20 crores. Stop. Close brackets. This is indeed surprising if the petitioners fail to participate in the reverse auction, within brackets, as was submitted on behalf of the respondents, close brackets, full stop. This is also, the figure given is also untenable in view of a document placed on behalf, a document placed before the court which shows that the petitioner's bid was for a value of rupees 4.91 crores. Stop. This is also the pleading in the writ petition. Stop. Hence, comma, by any stretch of logical or constructive or reasonable assessment of the material, comma, the figure of 5.20 crores could not have been reflected against the name of the petitioner on the portal of the respondents. Stop. Next. Learned counsel appearing for the respondents was learned counsel appearing for the respondents, respondent ESI Hospital, is averse, is not agreeable to comma upon instructions, comma, to permit the petitioner number 1 to participate in the reverse auction or to hold a fresh reverse auction. Stop. Next. Since, comma, this court has found irrational and arbitrary decisions on the part of the respondents bordering on self-destructive cases being made out, comma, this court is inclined, this court is of the view that until the matter is considered on affidavits, comma, there should be an injunction on the respondents to proceed any further with the reverse auction. What is the end date of the reverse auction?
11th April is ended.
To proceed any further with the bid, including issuing work orders in favor of the successful tenderer, bidder / S. Stop. Next, affidavit in opposition within
4 weeks. 2 weeks. No,
2 weeks. Reply within
Well, 1 week.
a week thereafter. List this matter after 3 weeks. Next.
3 weeks से चला my lord, private respondent is the existing contractor, my lord. So, my lord, may the hospital, my lord, engage someone else, my lord, because they will be in an advantageous position even after this.
Mr. Bandyopadhyay, I have stayed issue of work order. Let us see after affidavits. Next.
My lord, only one thing, my lord, in ordering portion, my lord, L1 is being represented. Respondent number 3 is the L1 bidder only. L2 is not being represented.
Respondent number 1, L1, respondent number 3.
3. Yes.
Yes. Jalpaiguri target.
Circuit Bench Jalpaiguri, item number 1.
Yes, Lordship, I am appearing for the alleged contempt. I am led by Mr. Arun Banerjee, Lordship.
I appear for the alleged contempt, my lord, meeting Mr. Devorshid Dhar. Your lordship, lord, directed us, lord, to file an affidavit, lord, explaining the delay. There is a compliance, but there is a long delay, my lord, in compliance. Your lordship gave us a chance, my lord, to file an affidavit, my lord, explaining the delay in complying your lordship's order, my lord. Now, this is the affidavit, my lord.
Well, we have just been served in the morning today around 10:30 a.m. My lord, I have gone through the content of the affidavit, my lord. I would like to use an affidavit against this affidavit, my lord.
What have you filed the affidavit for? To explain the delay?
To explain the delay in compliance of your lordship's solemn order, my lord. Present order has been passed, my lord, but A delay of 3 years.
Very well. The respondent, the alleged contemnor, only one.
One, my lord.
The alleged contemnor. Has filed an affidavit in compliance with the order passed by this court on 27 March 2023. Stop. Next, learned counsel appearing for the petitioner seeks to file a reply to the same. Stop. Yes, reply within
1 week, 1 week.
the reply shall be filed within a week from date. Stop. List this matter on 28th April 2023.
Much obliged.
Much obliged, my lord.
Reply to be filed within the returnable date.
Circuit Bench Port Blair, item number 1.
My lords, on the last occasion, my lords, I had placed Justice Gangopadhyay's order, my lords, where my lords, his lordship had observed that, my lords, the order whose contempt is being sought, my lords, which was according to Justice Gangopadhyay, that was obtained by fraud. And Justice Gangopadhyay had imposed cost of 10 lakhs. My learned friend had informed the court that they have preferred an appeal against Justice Gangopadhyay's order. My lords, the division bench on 3rd of April 2023, my learned friend is just passing the order while setting aside that part of the order regarding imposition of costs has restrained my learned friend from proceeding with the contempt without the leave of the division bench. My lords may see the order of 3rd April 2023.
Challenging the order of single bench, my lord. We were not heard when the order was passed by Justice Gongo.
This is the order of the division bench, my lords.
We preferred this appeal and this is the order, my lord.
Yes, yes.
Cost was set aside.
My lords may see the last page.
Which is the material page?
My lord, the
Yes,
material
my lords, last page.
Citing the contempt, internal page 3, my lord.
Yes.
Second paragraph.
No,
Fourth
third
paragraph.
last paragraph.
Just 1 minute. So far as this content petition is concerned, my lord, I was permitted, my lord, to seek direction, my lord, from the circuit bench who will be hearing the Ponzi matter to pursue the content petition.
Very well.
So in view of such, my lord, I would respectfully submit, my lord, lordship would, my lord, kindly adjourn this matter and permit me, my lord, to mention the matter once, my lord, I get the, my lord, approval from the division bench of.
Very well. How much time do you want?
My lord, it depends. We would be approaching the court, my lord, as and when the circuit sits, my lord, circuit bench, probably on 17th. So
Very
give
well.
us some time, my lord,
Yes.
3 weeks.
Learned counsel appearing for the parties places an order passed by a division bench dated 3rd April 2023 from in appeal from an order passed by a coordinate bench dated, what was the date of Justice Gangopadhyay's order?
My lord, 24th March 2023.
24th March 2023. Stop by the said order, comma, the division bench gave liberty to the appellant within brackets petitioner before this court, close brackets, to seek directions from the circuit bench to pursue the contempt application which has arisen from a violation of an order passed by this court on 25th August 2022. Stop. Next, a learned counsel appearing for the party for the petitioner seeks time to take the required steps. Stop to seek appropriate recourse. Stop. Next, list this matter.
Give us 3 weeks time, my lord.
After 3 weeks, as prayed for.
I'm grateful, my lord.
Next.
My lord, kindly, my lord, keep this order, my lord, appeal court's order on record, my lord.
Yes, the order passed for the division bench is kept on record. Next.
Grateful, my lord.
Most good.
Which is the part heard matter? Who is waiting for the part heard matter?
I am waiting, my lord, only to file the written notes of
No,
arguments.
then not today, you come back next week. অন্যটা ডাকো তো, পরেরটা ডাকো। পাঠাটা ডাকো, আমি এটা অর্ডার করে দিচ্ছি।
Part-heard matters, item number 155.
Yes, list this matter on 20th April 2023.
Lord, may I file the returns ready?
No, on the next day. Next. না না, হ্যাঁ ওর কন্টেম্পটা ডাকো তাহলে।
Contempt application, item number 156, Sigma Railway System.
As I had indicated to your lordship earlier, my lord, we do not wish to press the contempt so that the
Microphone, please.
my lord,
Yes, yes.
do not wish to press the contempt, my lord. The main writ petition is what we are, my lord, made.
Yes.
My lord, if that can be, my lord, kept, my lord, as a fixed matter on Monday, my lord, I express to your lordship the urgency, my lord.
The where is the order, Mr. Shah?
What, I'm sorry.
Page 40.
There is the contempt.
Contempt to
Page 40.
My lord, the order is with me, my lord.
Very well. Yes.
It's an order dated 9th.
The present contempt arises out of an order passed by this court on 24/1.
No, 9th February.
Which page?
Page 44. Kindly come to page 44, ma'am.
Yes, 9/2/2023. Stop. Next, the petitioner, next, learned counsel appearing for the petitioners, however, does not wish to press the contempt on the ground that the writ petition is required to be heard on an expeditious basis. Stop. Next, CPAN 245 of 2023 is accordingly disposed of in terms of the above. Stop. এটা কি writ petition সঙ্গে এসছে তো নাকি?
Yes, my lord.
Yes. Let the writ petition be, let WPA 1050/2023 be listed on 17th April 2023.
I'm very
As
grateful.
paid for.
May I pray for one indulgence, my lord? Sorry, there is a CAN number in the contempt application.
My lord, the can also be, my lord, disposed of.
For dismissal of the contempt application for other reasons. Since
This
the-
is filed by you?
My yes.
Very well. ওই যেখানে বললাম writ petitionটা লিস্ট করো, তার উপরে করো তাহলে কন্টেম্পটের পরে। CAN 1 of 2023 filed by the railway,
Yes, ma'am.
filed by the
Alleged contempt.
filed by the alleged contemnor is also disposed of in terms of the above.
And another thing, my lord, the last order passed by my lord, they were supposed to file a reply. That date has gone. Today in the morning, or no, in the afternoon, my lord, they have given a
Yes,
500 pages document. 2 sets.
yes. It's the same annexures.
May I just, may I just, this should have been told, my lord, be that as it may. There are more than 500 pages in each. Instead of 17, maybe on 19, because we may have to come back on the factual aspect, my lord. Can you see more than 500 pages of volumes?
My lord, may I say this, my lord?
No, if
The
the-
documents are the same. My lord, my learned friends have been served, my lord. We have,
Well, I cannot interrupt my learned friend, but 32 annexures in the reply. I am only praying for a liberty.
32?
32 annexures.
That's nothing. I thought you said 500 or something.
500 pages document.
my lord, these are, my lord, all the pages are there, my lord. My learned friend knows each of these documents. It is nothing new.
If my lord feels.
Mr. Ray, all superfluous and unnecessary. Ignore those documents.
No,
Let
I
us-
am praying for this, essentially for my lord. The case has been in my, we will show it then, my lord, then kindly keep the, because I.
My lord, may I start on Monday, my lord?
Yes, let him start on Monday.
May I start,
If my
Mr.
lord feels that we require a factual rebuttal to this, kindly give us that opportunity. That's only fair, nothing else. Because they, according to.
So you don't want to make submissions on Monday. That's what you're saying.
I want to file an affidavit.
But
in regard to that.
he has not even seen what the documents are. He should not produce them.
There's a.
This will go on unnecessary.
Mr. Ray, let me put the matter on Monday. Let Mr. Shah start.
Yes, ma'am.
You will get your time to make submissions.
Well,
All right. Without even having the papers in front of me, how can I say affidavit in opposition?
Not that.
no, affidavits are complete. All affidavits are complete.
Reply, a new story has been made. If that's why I'm saying in the first, because I said, if my lord feels that a rebuttal on facts is.
I don't have any opportunity to feel anything
Well,
because I haven't seen anything.
My lord, I cannot, my lord, possibly make out a new case than what I've made out in the writ petition. That would require an amendment. My lord, I shall make my submissions, my lord, on the writ petition. I have only dealt with, my lord, all the allegations that my learned friend has made in his opposition.
You shouldn't have made out a new case, Mr.
No, of
Shah.
course no.
Why have you done that?
I could not have and I have not.
Because the contempt is now dismissed.
Yes. Yes. 17th boleche ki? 17th. Yes. Original side. On Monday. Original side. I can't understand a single thing.
I was supposed to file, my lord, notes of argument, my lord. Today, my lord, was the date, my lord.
Original side matter?
No, my lord, appellate side matters, my lord.
No, original side, no. Which matter is this?
That PGM, my lord, where my lord, your lordship has directed us. This matter, my lord, related to my lord, WP number 27798, my lord.
You come back on Monday. Yes. Next.
My lord, I'm appearing for the respondent bank. I'm led by my learned senior in this matter. Item number 1, your lordship, respond number 3.
Item number 1.
Yes.
What do you
And item number
just keep
2.
quiet? Let the matter be called on. What is all this?
Item number 1 for judgment. 1 and 2. Nilesh Parekh.
This court hence finds no basis in fact or in law to interfere either with the impugned show cause notice or the impugned orders of the identification committee and the review committee. The petitioner has not been able to show any infraction of the provisions of the master circular. WPO 2768 of 2022 and 772 of 2023 are dismissed without any order as to costs in view of the above reasons. Mr. Chaudhary, simple reason. I could have actually given the judgment in one line. They did not give you the document because they did not know what to give you. That's why. Anyway, I wasted 7 or 8 pages. Yes. Next.
Item number 3.
Lord, this is a combined challenge to willful default and
You're now specializing in that. I'm going to dismiss it. Even without opening the papers.
No, this is worse. Here, my lord, there is
Here the petitioner also did not know what document to ask for.
again, my lord, forensic audit. Plus, my lord, it gets better, my lord. But there's some silver lining because the Supreme Court has now delivered a judgment which says that you want to proceed under the RBI circular for if Supreme Court has not delivered a judgment recently saying that if the respondent wants to proceed or if a bank or authority wants to proceed under an RBI circular pertaining to fraud, then hearing is required to be given because the consequences are disastrous. So two-pronged, my lord, issue. Number 1 is...
No, that I remember, the Chief Justice of India's order a judgment saying that before an account is held to be a fraudulent account or an NP or whatever that was, hearing must be given.
Yes.
Something to that effect.
Yes, yes. It's not a fraudulent account. This is... now, my lord, I have here, there's been some delay. Identification committee identified us as willful defaulters. Page 353, my lord.
This happened on 29th of April 22. There was, my lord, substantial negotiation for the purpose of trying to pay back the entire money, which however ultimately didn't appear. We also, my lord, because we were trying to forge a settlement, we also did not prefer a review petition before the review committee. So my time, my lord, has
So
lapsed.
what is 353? This is the document on a challenge.
Yes, my lord, one of the two. So, my lord, without, my lord, if my learned friend can take instructions, I am, my lord, humbly praying that instead of
Your learned friend can't make. What instructions will you take? Microphone,
Your Lordship, as to what Mr. Chaudhary just said,
microphone.
as to what my senior friend said right now, the Supreme Court has sometime back. বন্ধ করে দিল।
Yes.
Your Lordship, can you hear me now?
Yes, yes.
Yes, my senior friend has just indicated that there's a judgment of the Supreme Court, which has indicated that I cannot proceed in a fraudulent account, classification of a fraudulent account without giving them a chance of hearing. Your Lordship will appreciate that I have given them 4 chances of hearing. They have come before me. I have given a reasoned order, and there has been a declaration to that effect. Now it is out of my hands. It has gone to the RBI.
So now it is in whose hands?
It is the hands of the RBI. I have given them notice. I have given them hearing. They have. I have
Hands
given
of the
them
RBI?
No, I am for the respondent number 2 bank.
No. This is under, you have declared them as a willful defaulter.
Yes, I have declared them. They have not
So
preferred
what
a challenge
now,
to the-
what is the RBI supposed to do after that?
there cannot be any challenge against me right now. I have proceeded as per law, as whatever stood there at that point of time.
Very well. What instructions do you want them to take?
Number one, my lord, willful default. There is an order of the identification committee. It's been a year, my lord, since that order was passed. My time to challenge.
What is it? You want to go abroad?
No, my lord, I want a chance to approach the review committee. Or, my lord, I'll press, my lord, the challenge on merits before your lordship.
So there's no lookout circular against you?
No. I would want to go abroad. That is a different matter. My lord, that's, my lord, first. Secondly, my learned friend says that he's referred me to RBI. Now, my lord, he's also gone, my lord, to places making complaints about me. He's also, my lord, lodged FIRs against me. All that is fine. But if he wants to proceed, my lord, under the circular, he must act in terms of the judgment.
So why can you not go before the review committee, Mr. Chaudhary?
The reason being, the notification, my lord, kindly have a look at the master circular.
There's a time for that?
There's a time limit, 15 days. We received it on 29th April at page 91. Period of 15 days, my lord, is over.
Yes, you take instructions and come back.
Lordship.
You know on what?
And my lord, he'll give me a hearing before proceeding under the RBI master circular.
But he must have taken
this
some
is not
steps.
willful default. This is on fraud. That's the second circular pursuant to the Supreme Court judgment. And he will, yes, I'm sorry. My learned friend is correct, my lord. That's another bank. So, my lord, I'll press that on the next day that they should act in terms of.
On the next day means what? That's a separate writ petition.
No, my lord, on the next day after when my learned friend comes back with the instructions.
You come back with the instructions whether you want to give them a hearing or not, and have the time enlarged. All right.
I will. Your Lordship
Yes.
will record a formal order to that effect.
I'll also, my lord, pray for an order that the other banks or all the banks should, my lord, act in terms of the Supreme Court judgment and give me a hearing before proceeding against me under the circular on frauds. That is the other.
Very well. The petitioner is aggrieved by an order of the identification committee on willful defaulters dated 31/5/2022. Stop. The order was communicated dated 29/4/2022. Stop. The order was communicated to the petitioner on 31/5/2022. Is that correct?
Yes.
No. 31/5/2022. Stop. Next, learned counsel for the petitioner submits that the petitioner intends to go before the review committee for a relook, re-look, but is prevented by the window of 15 days, which has long passed. Stop. Which has long gone. Stop. Next, the respondent bank is represented. Which bank is this?
But to UCO Bank.
The respondent UCO Bank is represented. Stop. List this matter on, yes, when will you come back with the instructions?
In a week.
List this matter on 28th April 2023 for the bank to take instructions in the matter.
Much obliged.
I'm grateful.
Next.
Item number 4, Drama India Private Limited.
I'm being led by Mr. Bachawat.
My lord, I had concluded my submissions on the last day, my lord.
Why is the appelicide matter tagged with this matter?
Lord, identical issue. Identical issue.
My lord, it relates to, my lord, Article
Same company also.
23A, my lord, of Schedule 1A of the Stamp Act, my lord. It's an interpretation, my lord,
Yes.
of that provision.
Yes.
My lord,
The appelicide matter has not been heard.
But it's exactly the same, my lord, legal point
Wait.
involved, my lord.
Yes.
Your lordship is hearing both.
party of the my lord, just 3 provisions, my lord, of the Act, my lord.
Yes.
If I may place, my lord, before the schedule. My lord, kindly come to section 2, my lord, which is the definition section.
Yes.
My lord, first is, my lord, the definition of,
Yes.
my lord, an instrument. Kindly take section 2, subsection 14.
Yes.
My lord, 214A.
Yes.
My lord, instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. My lord, we are, my lord, really not concerned with B. And then C, my lord, any other document mentioned in Schedule 1, but does not include such instruments as may be specified by the government by notification in the official gazette. So, my lord, the, my lord, definition of instrument, really what we are, my lord, concerned with here, my lord, would be, my lord, any document which creates any right or liability or purports to be created, transferred, limited, extinguished, or recorded, or, my lord, a document mentioned in Schedule 1. Now, my lord, kindly have a look at section 2, subsection 10, my lord, which is, my lord, the definition of conveyance, for which, my lord, there is also a West Bengal amendment.
Yes.
My lord, may I first place, my lord, 210. Conveyance includes a conveyance on sale. And, my lord, all these, my lord, are inclusive definitions, my lord.
Yes.
Includes a conveyance on sale and every instrument by which property, whether movable or immovable, is transferred inter vivos and which is not otherwise specifically provided for by Schedule 1. Now, my lord, kindly have a look at the West Bengal amendment.
Yes.
For the words and every instrument, the words and figures, every instrument and every decree or final order of any civil court or every order made by the High Court under Section 394 of the Companies Act in respect of amalgamation, merger, reconstruction, or demerger of companies other than amalgamation or merger, so and so, of 2 banking companies shall be substituted. In other words, my lord, every instrument which, my lord, courts have held would in any event cover orders of court and, my lord, orders passed in, my lord, scheme applications. My lord, it's, my lord, really, my lord, clarificatory amendment, my lord, which makes it clear that, my lord, even orders of court, my lord, would be, my lord, covered, including, my lord, an order passed, my lord, in, my lord, a 394 order.
Yes.
So it's every instrument and every decree of final order, so and so, of civil court, or every order made by the High Court, so and so.
Yes.
Then, my lord, B, for the words, my lord, transferred,
Yes.
the words or any estate or interest in any property is transferred to or vested in any other person. So, my lord, again, my lord, it's widened. Then, my lord, subsection 2, my lord, kindly see, to clause 10, the following proviso shall be added. Now, my lord, the proviso is provided that on or and after the constitution of the National Company Law Tribunal, the expression High Court shall be read as tribunal. So, my lord, wherever, my lord, High Court, my lord, is mentioned, it will be read as, my lord, tribunal. And, my lord, there's an explanation. Kindly have a look at the explanation. An instrument whereby a co-owner of a property having defined share therein transfers such share or part thereof to another co-owner of the property, or divides such property among co-owners, or where a partner transfers his share in the property of the partnership business to another partner or to other partners, whether separately or together with transfer of other business assets on retirement or dissolution, or whereby he contributes to the capital of the partnership by transferring so and so for the purpose of this clause, an instrument by which property is transferred. Now, my lord, the reason for introducing it, your lordships, my lord, aware, my lord, partition, my lord, everybody has an interest in property. There would be no transfer otherwise in law. My lord, this is, my lord, saying even that would amount to transfer for the purpose of Stamp Act. Similarly, in partnerships, my lord, partnership, my lord, is, my lord, what's brought into the joint stock. So, my lord, even immovable property was treated, my lord, as movable. My lord, in, my lord, as partnership stock. That, my lord, is also saying, in spite of that, you will pay as if there is a transfer, my lord, of property. Now, my lord, kindly come to the charging section, section 3, my lord, which is, my lord, and my lord, the reason I'm placing this, my lord, is, my lord, for, my lord, interpretation of 23 and 23A. My lord, kindly see section 3. Subject to the provisions of the Act and the exemptions contained in Schedule 1, the following instruments shall be chargeable with duty of the amount indicated in that schedule as the proper duty, therefore, respectively, that is to say, every instrument mentioned in that schedule, which, not having been previously executed by any person, is executed in India on or after the first day of July 1899. Then, my lord, we are really covered by this. My lord, B and C we are not, my lord, concerned with. And, my lord, the proviso, my lord, is also, my lord, not, my lord, applicable. Now, my lord, kindly have a look at, my lord, Schedule 1A. Yeah. My lord, just one other thing I wanted to show. My lord, kindly take Schedule 1A, my lord, which is, my lord, stamp duty on instruments in West Bengal. My lord, kindly come to 23, my lord, Article 23.
Yes.
My lord, conveyance as defined by Section 210.
Yes.
Then, my lord, it says, not being a conveyance under number 23A and not being a transfer charged or exempted under number 62. Now, my lord, so, my lord, if it's a conveyance, which is not that which is mentioned in Article 23A, my lord, 62, I'm forgetting, my lord, for the time being, 6% of, kindly see, the market value, in case the market value of the property does not exceed rupees 1 crore, and 7% of the market value in case the market value of the property exceeds rupees 1 crore, when the property is situated in the areas to which the Kolkata Improvement Trust, it should be Improvement Trust Act or the Howrah Improvement Act extends. Then, my lord, again, my lord, on my lord, municipality, my lord, it is, my lord, where there's a municipal corporation or municipality, it's 6, and my lord, 7%, and my lord, with C is 5% and 6%, my lord, where, my lord, the property is situated other than, my lord, Kolkata Improvement Trust area property or Howrah Improvement Trust area property, or, my lord, a municipal corporation or municipality. So, my lord, really, my lord, rural areas which are not, my lord, part of a municipality, or, my lord, an urban conglomerate. My lord, it's based on value and, my lord, location.
Yes.
My lord, the rates of duty. Then, my lord, that agreement also, I need not trouble your lordship with agreement for sale. Now, my lord, kindly come to 23A, which we are really, my lord, concerned with.
Mr. Mukherjee, you want to come back?
My lord, I'll come back. My lord, today, my lord, deemed Friday, my lord.
Even Friday, you're running away. But he has a flight to catch, I guess. That's more.
Yes, you can leave, Mr. Mukherjee.
Obliged, sir.
Yes, tell me when you want to come
My
back.
lord,
And just give me the date.
my lord, could it be next Thursday, my lord?
Yes. The learned Advocate General, appearing for the state respondents, will continue with his submissions on 20th April 2023.